in for adjournment, Lordship.
Other sides?
I will inform, I try to trace them, Lordship, but unable to trace them. But during
You are appearing on behalf of?
the state government, Lordship.
Okay, on request made by MS?
As for
Yes, Conway Leonard,
Standing Council Elementary Education.
Leonard Standing Council Elementary Education Department. When do you want?
After 2 weeks, Lordship.
Please come.
Malad, it is the urgent matter relating to the market settlement, madam. Considering the urgency, your lordship had passed order for justice service, madam. We have completed justice service and justice affidavit was filed, madam. And thereafter it was listed on 7th in order. But the orders passed for a listing case for admission after 4 weeks, madam. After matter is urgent, madam, if the PA is not considered after 4 weeks, my petition will be in fact, madam. So kindly list the matter day after tomorrow, my lord. Otherwise the matter will be in fact, my lord.
Now, how will it become infectious?
Because the stay, paper stay was there.
Oh,
If they take the possession that the stay will be, infectious.
no, position of what?
Possession of the market, madam, collection of revenue,
Collection of it.
revenue.
Okay.
Kindly consider, my lord.
Okay, question.
Can't we have it on Tuesday?
My lord,
We can have it on Tuesday.
Tuesday, Tuesday. Tuesday, next week.
First
April.
April.
first April
Ah.
of president.
May
Oh.
please, Lordship. With regard to item number 72, my lord.
Oh.
As per instruction of my client, my lord, he have received the non-payment of bill, my lord. Yesterday, my lord.
Yesterday.
Yes, my.
Yes, madam. The matter
This
has
is
been
what,
processed.
this is that issue that Dar was saying it has been so. Okay. MS,
RS Deori, my lord.
Learned Council for the petitioner submits that during the pendency of the petition, the petitioner has got his relief. Accordingly, the matter has become in practice. Mr. R. Leonard's Standing Council appears for the Handloom, Textile and Sericulture Department, and Mr. H. Alia, Leonard Standing Council appears for the Finance Department. The petition is disposed of as infractious.
Please, my.
May I please, your lordship, this matter relates to settlement of fishery.
Hmm.
I am the highest bidder, my lord, the private respondent is not the highest bidder. He has been settled the market matter. Can it be taken up day after tomorrow as motion matter? Motion matter,
Or that is
day after tomorrow.
Fishery, okay.
Fishery.
Yeah.
May I please?
Oh,
So I beg to mention item number 26. This matter may kindly be taken up after week, month,
after
after a week.
26, okay, on request made by JMH Avril and Council for petition. Please, doctor. What week?
What
In first week of April, also, still is operating there. We have sent for affidavit betting. First week of April,
But they're supposed to file affidavit, they have not filed affidavit in
we
this
will file
case.
within the 2 days file. And then also on
Then lordship.
fourth course.
Okay, 4th April.
Back to mention for listing matter for admission, lordship, kindly first April,
5th April.
5th April, obviously.
Recommendation item 56. Lordship, this matter has been wrongly listed and orders found. Other service has already been completed.
Okay,
56, Lordship, and we see the Lozama Court's order 2011-2024. Let us. Twenty 2012. Flag mark is there. 2024.
yes,
Service has already been done. So it should become on admission government.
let it reach, we'll pass orders
Okay.
when it reach.
Maybe. I beg to mention item number 38, my lord.
30,
38, my lord. This matter, my lord, some development is going on for payment, my lord.
Hmm.
May come after 2 weeks, my lord.
okay, on request made by Mr.
Take care, sir.
Leonard Council for petition. Please, after 2 weeks.
Same prayer, my lord, regarding item number 49 to 54, my lord. Some development is going on, my lord.
Same order.
All right.
No, 54, 1 minute. Up to 53, no? Not 54. Yes.
My lord, this is settlement by town committee.
Oh,
Regarding the market, the last day is 31st March financial year. But the case is pending, so we could not issue further tender notice. So it may kindly be listed day after tomorrow.
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 Yes.
Tomorrow.
62 of supplementary list, withdrawal.
May I please, Lordship?
Huh?
Lordship, I have received instructions from my client not to pressing this petition, Lordship.
You have received the payment?
No, Lordship, the petitioner is not, had not received the payment.
Okay. But you are instructed to withdraw.
Yes, instructions I have received from the.
MS Dianganal in account with the petitioner submits that she has instructions to withdraw the present litigation
Liberty may be given, Lordship.
with liberty to file a petition. What resource was appearing? Government Advocate Mr. K. Gogol and additional senior government advocate appears for the state respondent. The petition is dismissed on withdrawal with liberty as to.
Always, Lordship.
61 of daily list, hearing.
Please, your lordship.
Hmm.
My lord, here we have. We have concluded our,
Yes.
I pray, my lord, I want to submit a statement of facts in detail, my lord, that document, my lord.
Your copy.
Yes. My lord, lordship, kind perusal, my lord, I have.
Okay.
Yes, pray. And another, my lord, in my lord, the statement of facts in brief, my lord, there is some typing error, my lord, 3, 4,
Where?
and that is, we have filed on 11/3/2005. My lord, I have submitted a corrected copy, my lord. I have submitted. 3 or 4 typing error, my lord.
Okay.
That's all.
Okay. Heard Mr.
A Bhattasan.
A. Kohli and Kohli. None senior counsel is by Mr.
Mr. Kulita and Anshul Malik.
A Malik.
A. Malik and petitioner also heard MSA Bhattacharya. None counsel to respond.
We are so grateful, Lordship, for so much time and indulgence. Deeply obliged. I think it's reserved for judgment now, Lordship.
Yes.
I'm grateful to Lordship.
Obliged.
One of daily list, motion.
So this is for violation of the order dated, my lord.
What is the order?
Lordship will find it page 13, my lord. Operated by page 16. The entire process was to be completed within 5 months, my lord. So almost a year. Nothing has been done. No payment of.
When did you file this
Which one, my lord?
contempt?
Contempt, my lord. In this month, my lord, in the month of March, my lord. The
Before
period has
the,
to be, my lord.
before the expiry of the
yes.
limitation?
Yes, because my lord, the 5 months was granted, my lord. So from it was the order was of 11/3. So 5 months
Okay, heard
thereafter.
Mr.
Are they?
Learned counsel for the petitioner issue notice. Petitioner to take steps for service of notice on the respondents 1 and 2 by registered procedure within 1 week. After 4 weeks.
Two.
We're up is 12 months.
Okay. But Mr.
M.H. Choudhury.
Then Mr. Counsel for the petitioner, issue notice. Petitioner to take steps for service of notice on the sole respondent by registered proceeding with up to 4 weeks.
327.
Item number 3, 4, 6, and 7, I have received my instruction.
How about 5?
5, I have not yet received, my lord. This person has already taken the final payment as well as they have withdrawn the performance securities, and they have not made any application before the dispute resolution board.
Have you received copies?
No, please. I will punish them. With regard to item petition number 1022. Second one, right?
1027, 1028, 1022. Yes.
Let's see. That's a petitioner challenge the sanction order that is whereby the respondent has deducted the huge amount as a liquidity damage.
The dispute has to be in terms of this clause 37(1).
Yes, but they have not take any compliance to appoint a expert committee.
First, they have to give an application before the dispute resolution board.
That's
After
why.
that, if it is rejected, they will go to arbitration.
Have you made any application before the dispute resolution board?
No, Lordship, we have filed representation before the respondent authority.
Then,
They have not communicated any. given any
according to them, final payment has been approved on
Performance security has been
and
withdrawn in some
security
cases.
deposit also you have withdrawn it.
No, in 3, 4, 6, and 7, we have not withdrawn that security deposit. Lordship.
You have withdrawn it.
No,
That as per the instruction it is there.
no.
Except item 5 you have got, 5 you have
I
not.
have not received instruction, but in Lordship will turn to the third page, man, that
Ah,
the third page. In one case, one school, he have not withdrawn it. In B, my lord, B, that particular school, he have not withdrawn it. And C also, he has not withdrawn it. Not applied for withdrawn for performance security.
But this
that is only in respect of one with petition.
Yes.
But in the other 3 with petitions you have withdrawn the security. deposit.
only the liquidity damages. Lordship.
That you'll have to make your application before the redressal board.
That observation may be given. Lordship.
After withdrawing the performance security also.
You have
withdrawn
withdrawn the
performance
performance
security also.
security.
Lordship, give the liberty to that observation may be given to approach the authority.
So you want to withdraw with liberty to approach the Mr.
P. Bora, Lordship.
Learned counsel for the petitioner. That is an item. 3,
3 to 7. Lordship.
all this with petition.
Yes, similar.
Same.
The plural and counsel for the petitioner press for withdrawal of this writ petition with liberty to approach the appropriate form. Mr. S. Bora, then standing counsel, appears for the SSA.
SSA.
SS. Writ petition is dismissed on withdrawal with liberty as per. Item 3, 4, 5, 6, and 7, you pass separate orders.
Hello.
What is this case?
Regarding settlement of market value, the petitioner at the lessee, my lord, your lordship on page 12.
Hmm.
page 12, we have been leased for the year 2024-25.
Okay.
But what happened?
Heard, Mr.
That's not.
Learn the counsel for the petitioner, issue notice. MS.
225.
Home and Political Department, Mr. K. Google and additional senior government advocate appears for the respond number 1. And MS RB Bora. Then the standing counsel BTC
Yes, Lord.
appears for the respondents
2, 3, 4, and 5.
2, 3, 4, and 5. Extra copies of the petition. Petitioner to take steps for service of notice on respondent 6, 7, 8, and 9 by registered proceeding within 1 week.
Published.
List of proposals.
Yes, Lord.
9.
Please, Your Lordship.
Well, I've got a very limited prayer, my lord. What has happened, my lord, here, the private respondent, my lord, he started the construction of, my lord, a building, my lord, by violating the site setback norms. My lord, I lodged a complaint before the, my lord, Procedural Municipal Corporation board, my lord. And the
Where's-
board, my lord, page 16,
Oh.
by an order, my lord, in the interim, my lord, stayed the, my lord, my lord, construction. And my lord, asking, my lord, the papers to be submitted by the, my lord, the party, my lord. Thereafter, my lord, the construction continued, my lord. I submitted a representation again, my lord, saying that the illegal construction is continuing, my lord, at page 18, my lord. And this construction has been continuing since then, my lord, without any, my lord, any action by the, my lord, respondent, my lord, board, my lord. My lord, Lordship will see, my lord, that I have given some photographs also, but before that, Lordship may kindly see the building permission, my lord, at page 20, page 21, my lord. The other, my lord, part is that, my lord, this permission was granted in 2020, my lord. Now, as per, my lord, the requirement, as per the act, my lord, municipal act, my lord, it remains valid only for 1 year, and it can be extended up to maximum of 2 years. Now,
It
he
was
has started
granted in 2020,
2020, my lord,
2020.
20, my lord.
Okay.
So it is valid for 1 year from 25 to 2020. My lord, then he has started the construction in, my lord, January 2025. Now, my lord, I have annexed some photographs, my lord. He has left no setback at all, page 25, my lord, you will see, my lord. It's just near to my boundary. So, my lord, page 25, my lord. And as per the requirement, my lord, he was at least required to, my lord, keep at least 3 feet, my lord, distance, my lord. So my prayer at this stage, my lord, is that since the board is not taking up any action, my lord, let them, my lord, decide this matter, my lord, by calling both the parties within a particular time frame, my lord. Because, my lord, this ultimately this is a factual determination, my lord. That's kind of simple, humble prayer, my lord. This is a simple prayer, my lord.
Anybody appearing for the board?
Board, my lord,
They don't have a standing. call.
Board and private respondent is there also. I am representing Asuna 1 also.
board has no, I think, standing counsel.
Private respondent is there,
Private respondent
Is there, my lord.
then maybe a notice should go once at least. Let them-
Notice may issue short notice.
That is true, my lord. Otherwise, notice will go.
Short
because-
notice and given
Mild.
the chance.
Yeah.
Basti also they
After that, we'll
they
pass
can.
the-
Mild.
They can take.
In the meantime, my lord, let the construction not proceed, my lord.
That part, Lucy, today we cannot do.
Or Mr. M. Datal and a council. Issue notice. Mr. K. Gogol and an additional senior government
Next time we will look.
appears for respondent 1.
One was.
1. Petitioner to take steps for service of notice on the respondents 2, 3, and 4
Two,
Mad.
2, 3 and 4. Lucy.
by registered proceeding within 1. Huh? You want to take Dusty?
My lord, otherwise, you get in.
Petitioner, additionally, petitioner is also permitted to post service of notice on the respondents 2, 3, and 4 by Dusty service to the registry of this court within 1 week.
My lord.
Within 1 week from today. So, thereafter, petitioner shall file an affidavit to that effect. List after.
But since it's a dusty, my lord, let date be fixed, my lord, because then, my lord, the date can be specified to them also.
Within a 2 weeks period, Lucy, they will.
Because otherwise, my lord, it becomes open-ended, my lord, the.
The Bihu holiday is coming,
Before 10 more, 11.
21st of April.
21st of April, my lord.
Because the Bihu holiday is.
I understand. The, my lord, the difficulty is the construction is going full
Yes, I
swing.
know. The prayer for entry shall be considered on the next sitting.
My lord.
No, we need to change the.
Can we before give him a 10 to 11? If it's others inconvenient your losses, madam.
When do you want?
The 10th or 11th, madam, before we probably
10th.
10th, madam. I'll take the same day.
You take Dusty and file your affidavit.
Madam, apply the lordship.
10.
Non-payment of contextual bill lordship. The respondent, after observing due procedure and formalities as a successful issued a evoke order lordship on 12/9/2017 lordship. And they have admitted lordship.
This respect, my lord, already an order has been passed, my lord, page 29. Annexure F.
They have made part payment lordship.
Third line from the bottom, third paragraph. Whereas it may be stated, the BTC conducted a comprehensive audit against the aforestated scheme in pursuance of the secretary order, so and so forth. As per audit report, the instant petitioner is found to be entitled a payment amounting to 50,000 for
50 lakhs.
50 lakhs, sorry. Whereas presently there is no availability of fund for disbursement of outstanding.
Yeah, Rabba, this is the financial period.
My lord,
This is the financial period.
yes, my lord,
Have you raised any demand?
for that I need. instruction.
Just see whether you have raised any demand.
Yes, ma'am. I'll obtain instruction in that.
Otherwise, you'll keep on saying no fund, no fund, no fund. That
This is
can't
what
go
I'm-
on for you. That cannot go on forever.
For that, my lord, I'll obtain instruction.
Now I don't know whether you can raise your demand at this stage. It's very late. Anyway, just take. Heard, Mr.
GG Google.
Gigi Gogol, learned counsel with the petitioner. By way of the present petition. Petitioner is praying for payment of outstanding dues amounting to rupees 50
lakhs.
41,600. Stop. Mr. Sarava. Learned standing counsel BTC.
Yes, ma'am.
Prays for some time to enable him to receive instructions. When do you want?
After vacation.
After Bihu?
Yes, ma'am.
Okay, list on 25th April.
11.
May you please, Lordship. Lordship, matter is regarding non-payment of contractors' bill, Lordship. On page 11, work order is there, Lordship.
Yes. Gogoi,
Take instruction. I have to take instruction.
you want instruction notice?
Yeah.
Instruction you take, it's not much, 7 lakhs.
Please, please, Lordship. We'll take.
Take instructions. Nothing much, 7 lakhs. But MS D Angana,
Yes, Lordship.
learned counsel for the petition. By way of the present petition, the petitioner is claiming for payment of outstanding dues amounting to 7,79,900. MS
Jay Gogol.
J. Gogoi, the standing counsel,
What are you saying?
Water Resources Department, prays for some time to enable him to receive instructions. Praise a lot. List after 2 weeks.
God bless you.
12.
Where the petitioner is aggrieved for non-release of his bills to the amount of rupees 27 lakhs, my lord. By the respondent authority, especially the respondent number 7, my lord. He was assigned in work to construct and renovate judicial quarters for the magistrate in Dhubri. After,
Dhubri.
yes. After the work was completed, completion certificate was also granted in favor of the petitioner, my lord. And there are, after I have given several representations, there are various inter-department communications also that I have annexed, my lord. But as of now, the funds have not
I have
been-
noticed, man, because he is approaching the court after 10 years. The matters pertaining to.
Okay, heard, Mr.
A. Dekha, lordship.
Learned counsel for issue notice. You appealing for?
I'm for 6 and 7.
Cannot be 6, 7
This
and
one,
8.
7 and 8, madam. Sorry, madam.
Okay, PWD. Your names are reflected here. Mr. B. Gogol and the Standing Council PWD appears for the respondent. 1,
1, 3, 4, 5, and 6.
Five,
I'm for 2 lots.
6. And Mr. K. Gogol and additional senior government appears for respondent number 3. And Mr. G. Baishal and the Standing Council. Guwahati High Court
One.
appears for the respondents 7 and 8. Stop. Notice on respondents to complete. However, extra copies. Respondents are not entitled to please stop the 4 weeks.
Right.
13.
May I please your lordship? Lordship, this matter may be fixed along with WPC 1872/23 lordship. Similar matter are pending lordship.
How much your amount?
It's a small amount,
1
lordship.
lakh
1 lakh,
15.
yes, lordship.
Okay, I heard MS KK Jawaril and the council. By way of the present petition, petitioner is praying for payment of outstanding dues amounting to 1,15,128. Stop. MS
M. Burman on behalf of Mrs. A. Gayan.
M. Burman and the council appearing on behalf of MS A. Gayan, then the CGC. Praise for listing this matter. Do on request, made by source. List the matter on 2nd of
2nd of April,
April, along with WBC number.
1872/23.
You got it?
Plus
14.
Now, in this case, my lord, the petitioner was settled with a fishery for a period of 3 years, my lord. The settlement order is at page 23. And in that, at page 23, it was stated in that settlement order that if there was any revenue to be paid, then it is to be recovered for means of land, areas from the land revenue.
Where is that?
That is at clause number 3, my lord. Should you fail to pay the revenue upon the dates named below, the same shall be recoverable from you as an area of land revenue at page 23. Thereafter, my lord, although they had written a letter to us at page 26 that we have handed over the possession to us, my lord, that they had handed over the possession to us, but the fact remains, my lord, is that the possession was never handed over to us. And in that regard, my lord, we had sent several reminders to them, which starts from page number 27 onwards, my lord, to hand over the fishery and also for demarcation of the fishery, my lord. To that regard, my lord, they have not taken any steps in that regard, my lord.
Till now.
Till now, my lord. And lastly, my lord, I have filed an application at page 51, my lord, on dated 18/3/2025 to the Secretary Fishery Department, my lord, whereby we have requested, my lord, that you hand over the possession of the fishery. And they may not take any coercive action against us, my lord, because the district commissioner of Obhyapuri, he is hell-bent on taking coercive action against us. And to that regard, my lord, I have made categorical statement in para 11 and para 17 that the co-district commissioner of Obhyapuri, respondent number 6,
Para?
para 11 and para 17, my lord. Para 11, my lord.
Yes.
And at para 17. My only prayer, my lord, is that
Representation.
may be disposed of, and they may not take any coercive action against us, my lord.
Fishery.
It's not there.
Who was that council?
He summarized them, my lord.
Names are SC name, fisheries name is being shown, my lord.
My lord.
Catch all of you. Catch all of
Yes,
you. After some time.
15.
Petitioners agree with non-constitutional petitioners case, my lord, under T development scheme, my lord.
Huh?
At this stage, notice may go, my lord. It's a scheme, my lord, T development and promotion scheme, my lord,
Okay,
under which petition is eligible, but they have not considered the case of the petitioner, my lord.
the SLC,
No, my lord, it's a development scheme. Some
The-
T board has
okay.
issued a scheme, my lord, T board of India, my lord.
Heard, Mr.
RS Mishra.
Learning Council for the petition, issue notice.
M.
Most
Burman on behalf of Mrs. R. Devi.
learner security appears on behalf of the,
All the respondents.
behalf of all the respondents. Notice on respondents are complete, our extra. Gonna allow the file after 4 weeks.
Deeply obliged, my lord.
16.
May I please, your loss.
Hmm.
The non-payment of contract bill, the award value was 1 crore 36 and 1 crore 26 has been paid. 10
How
lakh,
much has been paid?
1 crore 26 paid, only my lord 10 lakhs remains unpaid. Statement of liabilities at page 16, my lord, annexure 5. Your lordship kindly, statement of liabilities.
Yes.
The claim they are making is after nearly 7 years, your lordship, 2018. And
Yes.
lordship, I'll have to take instruction in this.
I'll issue notice.
Lordship.
Let them
very
take instruction by at motion stage, it can be
You're
disposed of.
coming after more than 7 years.
More than
That is
7 years.
correct. But
Heard, Mr. N. How, learning council. Issue notice. Corporation Department,
Yes, your,
Yes.
I am appearing.
Mr.
V. Rajpal, your lordship.
B. Raj Goa, learner standing council, Corporation Department.
Respondent
Appears
one-
for 3, 1,
1 to 4, your lordship.
1, 2, 3, 4.
1, 2, 3 and 4.
4. Finance,
5 finance.
5 is fine.
Mr. H. Alia, learner standing council, finance, appears for the respondent number 5.
Only page 30.
Notice on respondent.
Maybe probably.
Our extra copies. Respondents are to file a list of problems. On top, you just say hurt so and so. Before issuing by way of, by this petition. The petitioner is claiming for payment of outstanding dues amounting to rupees 10,08,000. Issue notice.
Probably.
17.
My lord, here also, my lord, annexure 7, page 26 may be seen, my lord. The bill amount is 63 and out of 60, 10 lakhs has been paid. And 53 lakhs 90,000 has not been paid. Page 26, my lord. Last column,
Who are for the respondents?
PWD department is there. And BTC is also.
Who is PWD and BTC? Gogo is there.
Wait, to say, right?
Possibly this is just notice, my I will inform them.
Hurt all and have to constitution. By way of the present petition, the petitioner is claiming for payment of outstanding dues amounting to rupees 53,90,977. Stop issue notice. Mr. B. Gogol, then standing council PWT appears for respondent. 1, 2, 3,
Finance or finance.
4,
1 to 6, my lord. 1 to 6, but technically.
1 to 6.
including PWD, standing on PWD and finance appears for the respondents. All the respondents,
All the rest.
notice and respondents are complete. Our extra copies. Respondents are allowed to file after this type of forms.
Obliged.
18.
My lord, here is the case, my lord. The various cooperative societies are allowed to transport the PDS system of articles, my lord. So, my lord, the petitioner societies are also, my lord, transporting the PDS article to the, up to the, collecting from the FCI and then up to the FPS shop, my lord, they used to transport and distribute the articles, my lord. Now, my lord, sometimes, my lord, in the 2024, there is a step taken by the state of Assam, my lord, that the PDS, distribution of PDS article to be given to the private respondent, not to the cooperative societies. and various cases has been filed and writ petition was disposed of, and one writ appeal also filed, my lord. In the writ appeal, there is an order, my lord. The writ appeal is still pending, my lord, for hearing. In the last paragraph, having regard to the facts and circumstances of the case and also consider the fact that the appellants are continuing to lift and distribute food grains from the designated depot, we direct the parties to maintain status quo in respect of existing system distribution of PDS commodities in so far as transportation is concerned. So, my lord, NIT was issued subsequently in various districts, my lord. And one of the district in Kamrup district, there is also a writ petition filed. Your lordship will find in Annexure 1. Annexure 1, applying this, complying this writ appeal, my lord, the status quo was granted by the Honorable Single Judge, my lord. In the para 7, page 30 of the operation part, page 30. In view of division bench of court number so and so, directing that the lifting and distribution of food grains from the designated depot should be carried out as per existing system of.
Okay.
Same, my lord, I am just, my lord.
How are you aggrieved?
Agree, my lord. Now again, my lord, action is taken by impugned communication during Annexure 3. So in Majuli district, it may be taken effect, my lord.
Where's Annexure 3?
Page 32. Now, last paragraph. In view of the above, as per
There's no Annexure 3 in the writ petition.
Annexure 3, my lord.
Arthur, if
How many? Oh, please. Page 32, 3 is missing. That.
How about the other annexures?
Annexure 2, my lord. Only this 3 is, annexure is there by right.
How about the other annexures? Check it up.
Yes, 1 is there. 2 is, yes, 2 mark. 2 mark.
How did the filing?
Sorry, madam, very sorry.
Accept the writ petition?
One is marked, 2 and 3, they have page 32. Again, my lord, in view of the above, as per discussion in the meeting of GPSS, FPS, and transporter in the office of the undersigned on 13/2025, you are once again requested to kindly go for fresh online tender for selection of soil and soil. I'm just, my lord, praying that existing system of transportation may be continued.
You are still continuing, isn't it?
Yes, it's still continuing.
No tender has been issued.
No tender is issued, my lord.
Then
because we are suddenly a tender may be issued by following this, my lord. So only with my prayer, the existing system may be, my lord, to continue.
you are apprehending.
Yeah, apprehending.
On apprehension, how can this court pass an order?
We are apprehending, my lord. Yeah.
Unless the NIT is issued, maybe this is only a communication.
Yeah, communication. This is a communication. So we are.
There's a stay order passed by this court.
Not stay, my lord.
Permitting
No,
others.
we may be allowed to transport, my lord, the food grains.
So, where's your cause of action?
My lord, because, my lord, the commissioner has already issued to the district, and they are going to take, they issue the NIT, my lord.
Maybe they will not issue in view of the division bench order.
It is division bench order only in respect of this Kamrup district, my lord. Only in Kamrup district. So just I pray, my lord, that we may be allowed to till NIT is issued. Till NIT may be issued. We may be allowed to continue existing system of distribution of public articles.
If no NIT is issued, where's your cause of action?
But till NIT is issued, we are appending from this, my lord, this letter, my lord.
After NIT is issued, then
then we have to come again for second petition, my lord. If it is so, my lord.
I don't understand. I just don't understand.
Notice.
There's no cause of action.
It is premature.
till NIT is issued. So therefore, no damage will be caused even both sides, my lord. If NIT is issued, then
If I
fresh,
pass in order in this writ petition, all the other districts will start coming. When NIT is issued, you can come back. We can withdraw
it will
this.
be late then again, my lord. There will be the time frame will be there. Process will be again started.
Immediately you approach, after that we can, in the other,
Or
in
what
the,
just my lord,
in the other case, NIT was issued.
the my lord, we will be allowed to represent deputy district commissioner in this respect about the present system of, we may be allowed to represent before the
That part,
district commissioner.
the hurt Mr. D. Sinal also. Stop. The petitioner is aggrieved with the communication dated 26 February 2025, written by the commissioner, food, public distribution, consumers affairs and legal metrology, Assam, and addressed to all the principal secretaries of autonomous councils, DHAC, KAC, PTC, Kokrachar. Where request has been made for fresh online tender for selection of new transporters for carrying food grains within bracket PMG KY within bracket rice under NF
NFSA,
under
National Food
NFSA,
Security Act.
by considering the impact of route optimization result within bracket distance under their jurisdiction, and to complete the process of selection of new transporters through e-tender process at the earliest. Stop. Para. Learned counsel for the petitioner submits. That the petitioners may be permitted to make a representation.
Yes, ma'am.
Before whom?
District Commissioner,
Before the district commissioner,
Majuli District.
Majulu district oblique respondent number 2 within a specific period of time. And the respondent number 2 may be directed to dispose of the representation within a specific period of time. Mr. M. Chitia Leonard, government advocate, appearing for
All respondent.
all the respondents has no objection. Accordingly, writ petition is disposed of, directing the petitioners to make a representation before the respondent number 2 within a period of 1 week from today. Thereafter, the respondent number 2 on receipt of the representation shall dispose of the same by speaking order and in accordance with law within a period of
Within a period of
2 weeks.
2 weeks, madam.
2 weeks from the date of receipt of the representation. The above resolution shall such a petition is disposed of.
Obliged.
19.
May it please, my lord. Pursuant to a NIT issued by the respondent number 3, that is the superintendent of excise, we had participated in the tender process for, my lord, IMFL, my lord, India Made Foreign Liquor.
Where's the tender?
At page 12, my lord. If my lord kindly comes to page 12. This is for shop number 14, ward number 9 under Thekiajuli Municipal.
Where's
Code.
that? Where's that?
That is at page 16, my lord, 16.
Shop number?
Shop number, my lord, shop number 14, the shop number column 14, page 16, my lord, shop number 14. Name of the shop, IMFL of location ward number 9 under Thekiajuli Municipal Board, Tezpur. Thereafter, my lord, we had paid the earnest money deposit of rupees 5 lakhs, my lord.
my lord would have the acknowledgement at page 20, my lord, of the petition, 20. At 19, my lord, because it belonged to the municipality areas, my lord, that is why we had to pay 5 lakhs, my lord, at the bottom portion, my lord. Page 19, bottom portion, in municipality areas, EMD shall be rupees 5 lakhs. Accordingly, we had paid rupees 5 lakhs. At page 20 is our acknowledgement. Now, my lord, this bid was issued on 12/1/2024. Accordingly, we had participated, we had paid the earnest money deposit. Since then, my lord, we have been kept in a limbo, my lord. They have not issued the technical bid. There is no progress, my lord. My lord, our limited prayer in.
When was the bid issued?
12/1/24, my lord.
Oh.
More than 1 year.
My lord, we'll fix this item, matter on Monday, my lord, or Tuesday. I'll have inspection, the reason behind, my lord.
Third, Mr. P. Sharma, Learned Counsel for the. Mr.
D. Gogol.
D. Gogol, Learned Standing Counsel, access to court. Place for some time, to enable him to receive it. Praise the Lord. When do you want?
Tuesday?
Monday.
So Monday bonus. Oh, sorry. Friday. It can be fixed on Friday also, this Friday also, limited instruction.
First step.
Deeply obliged, my lord.
20.
We'll pay only for a notice in this case. This is a fishery in question where allotment was given in 2022 for a period of 3 years. Now, the position they could not hand over. Fishery rule says that not only position has to be handed over. It was not handed over because one of the private party was disturbing us because a huge area. One of the dark number, there was a particular area which belongs to the government. That is why the allotment was given. Government tried earlier also to by way of putting off a tender, but no participation was coming forth because there was a huge area of dispute. Ultimately, a suit was filed by the private party in before the learned trial court, in Bongaigaon. A suit was filed and there was the injunction which was granted. Thereafter, we preferred an appeal before the learned civil judge. Now that appeal will come up in the month of 23rd of April. Now, in the meantime, the reason why we have come up before this court, 3 years is going to be expired. Now, all the KISS money has been paid. All the KISS money has been paid. So I think at this stage, your lordship will not pass any order. Your lordship simply issue a notice because when it is going to expire?
6 July.
6 July.
Oh, July, it's expiring.
That's why, that is why I'm saying time is there.
But Mr. D. Das, Learned Senior Counsel.
Minor.
Yes,
In this case, my lord, he's from a presiding because he will appear, my lord, after some time, my lord. He's coming. my lord. See, I'm like.
Issue notice on this. Assisted by Mr. S. Count. Learned Counsel for the police. You are appearing for Chitia?
4, 5, and 6. Before 4, 5, and 6.
Mr. P. Sharma, Learned Standing Counsel, Fishery Department, appears for the respondents, 1, 2, and 3.
Yes, my lord.
And Mr. M. Chitia, Learned Government Advocate, appears for the respondent, 4, 5, and 6. Extra copies. Respondents, petitioner to take steps for service of notice on respondent number 7 by registered proceeding within 1 week. List number 4 weeks.
I'm deeply obliged.
63 of supplementary list, motion.
Please, the last date, my lord, inspection was for my lord. And petitioner here, my lord, in terms of NIT dated, my lord, 16/8/2024, my lord, he had participated. And in the competitive statement, my lord, he was placed as L1 bidder, my lord. But subsequently, my lord, the
Let it be a through, my lord. My instructions are on the way, my lord, on my or Friday, my lord. I tell you, 2 or Friday.
Or tomorrow?
Tomorrow also.
Third is constitution on requestment by B. Google, understanding function PDF. This the matter we can all. Tomorrow. 27.
Well, it can be Friday, my lord.
Friday will be some difficulties. Or we can have it on 1st or 2nd.
My lord.
Then, my lord, on first. For second, my lord, there's a Wednesday.
2nd.
Second. Second of April.
My lord, in the meantime.
No. Then, my lord, let it be tomorrow.
Tomorrow, my lord.
64.
I raised the lordship passes over the matter for the time being, for a short while. My friend Mr. P. Bharadwaj will argue the matter. He's on legs in court number 1. 64 and 73, I assume, are tagged matters, Your Lordship.
Lordship, in this matter, I have filed IA.
Where's your IA?
Yes, Lordship, but not listed today, Lordship. I have filing number 3746, Lordship. Or Monday, Lordship, Tuesday, Lordship, along with the IA 3746.
Or Friday?
Friday will be difficult. Okay, heard Mr. M. Sharma on the counsel for the petition. MS R. Kakutil and the counsel submits that she has filed in IA.
Filing number
For impleadment and the present petition, and the filing number is
3746 2025.
3746 oblique 2025. Release this matter along with the said IA on
Monday?
Yep.
Monday is a holiday.
There's a holiday.
Wednesday.
Yeah, second.
65.
This is regarding the supply tender of cardiac monitors. Instruction was supposed to be.
My lord, I've got the instruction, my lord. As per my instruction, my lord, not only on one ground, my lord, the petitioner's technical bit fails on 6, my lord, ground. So I'll file my affidavit because it will have to be after.
Okay.
Only thing, my lord, there is some urgency on our part, my lord, regarding the, my lord, supply of that, my lord, life-saving machine. Can it be, my lord? I will file my affidavit by, my lord, Tuesday.
Fine.
Okay.
He may like to file a reply.
Yes, Lord, sir.
Yeah.
Another week's time for someone to have a reply.
But Mr. Isha, notice has not gone.
Yes, Lord.
Lordship may issue notice.
Any other parties?
My lord,
The L1 Lordship, private respondent.
he may be allowed to take dusty, my lord.
You take by dusty service. Can you do
Lordship,
it?
this is New Delhi, Lordship. New Delhi.
See, if notice will have to go, then
Then again, my lord.
And only one aspect of the matter, Lordship. They are saying that there are 6 grounds, but the ground communicated to me is only 1 ground.
It has been
Today they
uploaded.
cannot supplement.
It is uploaded, man, already uploaded.
But
There is
A.
some
Sharma,
query
let
that
me
was-
counsel the petition. I'll issue notice.
Yes, Lord.
Lordship will issue notice, but my lord, Lordship will fix it on 8th of April. Let us see, my lord. We'll also intimate them.
Notice will not go.
We can intimate them, my lord, by the office, my lord. We can intimate for
Okay.
this case. If they come, my lord, well and good.
Issue notice. Mr. B. Gogoi, Leonard, Standing Counsel Health Department, appears on behalf of respondents. 1, 2, 3, 4.
Till 6, Lordship.
Yes, still 6.
One to the respondents, 1 to 6. And submits that he has received instructions. And will be filing affidavit within a period of 1 week.
Yes, my lord.
Within a period of 1 week. Stop. Let such affidavit be filed on or before. When can you file it?
My lord, I can file it by, my lord, 2nd of April.
On or before 2nd of April.
By 7th of April, I'll file my reply, Lordship. If Lordship wants to have it on 8th, then by 7th, I'll file my reply.
The petition is also permitted to file reply to the affidavit filed by the respondents 1 to 6.
Got it.
Petitioner to take steps for service of notice on the respond number 7 by registered post AD within 1 week. Within 3 days.
Yes, Lordship.
Within 3 days. Stop. Considering the urgency involved, Mr. B. Gogoi, Leonard, Standing Counsel Health Department, submit that the respondent number, that the respondents, that the official respondents, that the respondents in the health department shall inform the respondent number 7. Stop. In that view of the matter, the petition is also directed to give an extra copy to Mr. B. Gogoi, then the Standing Counsel for serving notice on the respond number 7 by to the officials of the health department. You file an affidavit also?
Yes.
That you have entered, drafted. The officials in the health department shall file an affidavit showing notice on the respondent number 7. So this is the matter on 8th of April.
The interim order may continue till then.
Interim order possibly continue till the next.
Obliged, Your Lordship.
66.
Lordship, this is the suspension order, Lordship, it is sought to suspend us without a show cause notice. A black for.
The blacklisting.
Blacklist. So, which they say they have done as per their process. Lordship, if I may take you, Lordship, initially what happened? We were issued a show cause notice, which is at Annexure 1. And our Annexure 1, Lordship will come to page 39. They have quoted the relevant provisions of the two letters. One letter which they wrote. What had happened? The facts. I think Lordship is aware of the facts. The design which I took
In
this
the earlier petition.
Yes, Lordship, that. And then, Lordship, they issued the show cause notice saying, in view of the above, it's apparent that a drawing was forged by way of deceit in signature, which is forged and is to be dealt with under clause 16 of the contract, read with the provisions of the Integrity Pact, which forms a part of the contract. Next, Lordship will come, then they quoted clause 16. A bidder contractor should note that ONGC may verify the authenticity of all of the documents, certificates, information submitted by the bidders against the tender in case at any stage of the tender proceedings or contract PO, execution, etc., if it's established that the bidder has submitted forged document, certificate, information towards fulfillment of any of the tender conditions, tender contract conditions, ONGC shall immediately reject the bid of such bidder, cancel, terminate the contract and forfeit the EMD submitted by the bidder. That's clause 16. Then can terminate my contract and forfeit my EMD. Then, Lordship, in view of the above, you have violated clause 16 of the contract and violated the provisions of the Integrity Pact. Hence, as per company policy, you are hereby being informed that an opportunity is being provided to you to submit a response within 14 days as to why ONGC should not terminate the contract and invoke the PG as per clause 16 pertaining to the authenticity of the document and suspend business dealings with you, that is Oval Projects Private Limited, for violation of the Integrity Pact. Now I replied to that. Then, Lordship, the termination order was passed, which is at page 57. I made it very clear that there was no forgery. In fact, the document which was stamped by me had later been ratified by the design consultant. That has been given. I've given documents to that effect. But nevertheless, Lordship, at page 57 is the termination order. They terminate, which Lordship will come to the relevant portion, which is at page 58. Whereas the competent authority in ONGC deliberated the contents of the reply of the show cause notice, was observed by the competent authority that clause 16 of the contract doesn't specify the type of documents or its commercial implications or the reason due to which the forgery has occurred. And so the said clause does not have any provision for letting go of such incidents. Messrs. Opal has also accepted the false submission of document by letter, their mail dated 22/2/2024. Further, even after giving assurance that such lapses will not be allowed in future, in its mail dated this, there was one more forged document submitted by Messrs. Opal pertaining to high mast, which was later confirmed by DEC Kevin by mail dated 15/5/2024, Annexure 1. Furthermore, ONGC never accepted the explanation given by Opel against the allegation of forgery, nor did it condone the forgery by extending the time of phase 1 of the project. Further, during the personal hearing, Mrs. Opel submitted a write-up on 28/2/2025 in personal hearing, wherein it was stated that Mrs. Kevin confirmed the document was correct and that no change had been made in the original. Instead, Kevin has submitted the document with a comment and instruction to Opel to resubmit after incorporating the comments within 7 days. Hence, the claim of Opel is incorrect, observing that the inspection report of oil storage tanks are carried out to meet the mandatory statutory guidelines. Delay in these actions has caused loss to ONGC. Now they bring in a new factor, and I've challenged this. I've challenged this, Lordship. Now, Lordship, and they say that they will take action. That is what they say here. Submitted, you shall be forfeited, and bank guarantee will be forfeited. They have forfeited that in accordance with clause 8.33. That's at the next page. Read with clause 16 of the contract. Further termination notice dated this forged documents in accordance with clause 8.33, clause 16 for violation of integrity pact, and you're liable to consequential action as per contract conditions. This I'm also liable to, but I don't know what conditions. Then, Lordship, I get a letter which is at annexure 4, page 62. Now, this is a letter by which I am put under suspension. Lordship, the facts are given in the first 2 pages. Next, Lordship, Lordship comes to page 63. Lordship will come after point 4. There's this. They have quoted my response, etc. They have quoted, then they have unquoted, and they write, now on the basis of factual scenario, the allegations of forgery by way of deceit in signature and stamp is dealt with under clause 8.33 and clause 16 and clause 8.37 of the general conditions of contract and provisions of integrity pact, which form a part of the contract. Then they quote clause 16. Then again they quote clause 8.33, which says, in case of termination, the contract under the provision of that clause, other than clause 7.4, 7.5, and clause 8.2 of the contract, the recourse as mentioned in the relevant clauses under which the termination has been taken, if it has become effective, shall be applicable. That's what they say. And now Lordship will read clause 8.3.7, which is also quoted here at page 64. Consequence of termination. In case of termination, herein set forth, the obligation of the ONGC to pay shall be limited to the period up to the date of termination. Now, notwithstanding the termination of this agreement, the parties shall continue to be bounded by the provisions of the agreement that reasonably require some action of forbearance after such termination. In case of termination of contract, herein set forth, except under clause 8.3.1 and 8.3.2, annexure 2, or annulment of the contract due to non-submission of performance guarantee, the following action shall be taken against the contractor. ONGC shall conduct an inquiry. Now, Lordship, here they'll find. Conduct an inquiry against the contractor. Consequent upon the conclusion of the inquiry, if it is found that the fault is on the part of the contractor, then they shall be put on holiday. That is, neither any tender inquiry will be issued to such contractor by the ONGC against any type of tender nor this offer will be considered by ONGC against any ongoing tenders where the contract between the ONGC and their particular particular contract as bidder has not been concluded for the period of 2 years from the date of order putting the contract on holiday is issued. However, the action taken by ONGC putting the contract on holiday shall not have any effect on the ongoing contracts, if any, with the that the contractor if any, with that contractor, which shall continue till the expiry of the period. If pending completion of the inquiry, the process of putting the contract on holiday, the contractor shall neither issue any tender inquiry to the defaulting contractor, nor shall consider their offer. So they'll have an inquiry and put me on holiday. Maximum is 2 years, Lordship, for a period of 2 years. Now, Lordship, next paragraph is section 6 of the Integrity Pact. Section 3 of the Integrity Pact. They say disqualification from the tender process and exclusion for future contracts. This is what it says. If the bidder before, this is not applicable, Lordship has come to next one. If the bidder contractor has committed transgression through a violation of section 2. Now, Lordship, section 3 talks of section 2. Section 2, such as to put his reliability or credibility in question, the principal is entitled also to exclude the bidder contractor from future contract award processes. The imposition and the duration shall be exclusion will be determined by the severity of the transgression. The severity will be determined by the circumstances of the cases, in particular the number of transgressions, the position of the transgression with the company hierarchy of the bidder, and amount of damage. The exclusion will be imposed for a minimum of 6 months and for a maximum of 3 years. A transgression will be considered to have occurred if the principal, after due consideration of the available evidence, concludes that no reasonable doubt is possible. The bidder accepts and understands accepts and undertakes to respect and uphold the principal's absolute right to resort to any imposition of such exclusion, and further accepts and undertakes not to challenge or question such exclusion on any ground, including the lack of any hearing before the decision. Not even such drastic before the hearing to resort to such exclusion is taken. This undertaking is given free and after obtaining independent legal advice. If the bidder contractor can prove that he has recouped the damage caused by him and has installed such suitable corruption prevention system, the principal may revoke the exclusion prematurely. Now, Lordship will come straight to 6. Lordship will come 5. Whereas the drawing and design forged by Oval at Agartala is a very basic execution of the work and is relied by ONGC to ensure quality work in the fields. Therefore, forgery of such document is to be dealt with as per the provisions of the contracts stated above. And whereas, considering the allegation mentioned above against the firm, competent authority approved conducting of inquiry of banning of business dealings with the firm in accordance with the branding policy of ONGC. The competent authority has appointed this as the inquiry officer to conduct inquiry against Oval along with business as per the provisions of the contract IP. I read with ONGC's policy for banning provision suspension business dealing with the firms, Messrs. Oval Projects Engineering Private Limited, Agartala, and along with their allied concerns, partners, associations, directors, proprietors involved in the capacity shall be banned after conducting the inquiry from the date of banning till the period for which the vendor is being banned. The period of suspension shall be adjusted against the period of banning determined after the inquiry. So, whereas it has been decided to put the firm on provisional suspension for the period of 6 months, holding pending inquiry for banning process. During the period of the provisional banning, suspension, the firm shall not be eligible to bid directly or indirectly through any joint venture, consortium, partners with any other bidder, etc., in any type of tender of ONGC and their offer, if any, in any ongoing tender shall not be considered, including consequence as mentioned in the ONGC's policy of
So
banning.
you are aggrieved by the provisional suspension.
Pending inquiry. They can only suspend me without giving me a show cause notice. This provisional suspension is not permitted. Even Supreme Court has said in a number of decisions that it is such a drastic, it's stigmatizing, it's just, you can forfeit your EMD, you can do such things. But when it comes to ban suspension, you have to give me a hearing, and there can never be a provisional suspension. Suppose in the end of the day, they find that I am not liable to be suspended. What happens to the stigma, to the 6 months? Those decisions of the Supreme Court are there. I can place before your lordship. This is what I'm aggrieved with. They have in their policy, suspend, you do, but that cannot go beyond what the Supreme Court, law is Supreme Court.
But, the issue pertains to two aspects. One is termination, which has been put to challenge.
That is a different issue.
This is pertaining to provisional suspension. Now, the question that has been raised is whether we have the power. So, first things first, one submission that has been made that we have not given the petitioner an opportunity of hearing. Your lordship will kindly come to the show cause notice, page 38. There is a show cause notice, and if your lordship will kindly come to page 39. The third paragraph from bottom, the paragraph starting in view of above. In view of above, you have violated clause 16 of the contract and violated provisions of the Integrity Pact. Hence, as per company policy, you are hereby being informed that an opportunity of is being provided to you to submit your response within 14 days as to why ONGC should not terminate the contract and invoke the PBG as per clause 16 of the so-and-so pertaining to authenticity of documents and suspend business dealings with you. So there is a very specific show cause notice on two aspects. One is termination and second is suspension of business dealings. Now the question as to why and how. If your lordship, that is the unfortunate part.
Chaudhary, if what I understand is that the show cause notice was issued for two things.
Termination
of the contract
and suspension.
Correct. Now, that termination petition is challenging in a different petition that I think it's listed.
Notice has been issued and your lordship has fixed it for.
Okay. So far, this provisional suspension is provided.
That is what I am.
So the notice is for termination and suspension. Correct. Now you're having an inquiry.
Well, that is what your lordship will kindly. We can equate this with a disciplinary proceeding. Now, contemplating disciplinary proceeding, the authorities can always place a person under suspension. And the question here is whether we have the power to do so and under what provision. Unfortunately, my lord, the contract itself has not been annexed. So, if your lordship will just allow me to place this.
I'll place the contract. I'll give the contract.
The relevant portions we have edited.
General conditions of contract, that's what you.
There are twofold. The power is conferred on us under the contract itself, and as well as there is a guidelines, set of guidelines followed by ONGC. If your lordship will first come to the contract itself, my lord, your lordship will find flag mark consequences at the first flag, clause 8.3.7. As my lord got it. The heading is consequences of termination. In that subclause 2, pending completion of the inquiry, process of putting the contractor on holiday, ONGC shall, your lordship will kindly note the word, my lord, shall neither issue any tender inquiry to the defaulting contractor and nor shall consider their offer in any ongoing tender.
That's fine. That's fine.
So basically it amounts to power conferred on the ONGC that till the inquiry is completed, we will not have any business dealings with the party.
Correct. Correct.
Now, if your lordship will kindly turn to, there is in that same bunch of documents, your lordship will find Integrated Materials Management Manual. This is a set of guidelines pertaining to all contracts by ONGC, as my lord got it. In the same bunch of documents, your lordship will find Integrated Materials Management Manual. This is a set of guidelines. If your lordship will kindly turn to the second page, your lordship will find 17.5 vendor banning. Refer policy for banning provisional suspension of business dealings with erring firms at an annexure VVP. This, if your lordship turns to the next page, that VVP is annexed. Now, serial in that chart, your lordship will find serial number 1, policy for banning provisional suspension of business dealings with erring firms. As my lord got it. Serial number 1, policy for banning provisional suspension of business dealings with erring firms. In these guidelines, unless the context otherwise requires, firm shall mean bidder and contractor also. If your lordship will kindly turn the page at subclause 3, next page. In case firm commits any of the following: fraudulent activity, forgery, gross negligence, etc., etc. In the right hand side, your lordship will find minimum 6 months and maximum 3 years. And then 1.2.2. Following are the grounds on which provisional suspension of business dealings, pending inquiry for banning of business dealings with firms shall be done. And again, the word is shall. A is fraudulent activity, B is forgery. So the power rests on the ONGC.
No, that's fine. I'm saying that you cannot suspend, but you'll have to suspend after an inquiry.
No. Pending inquiry, we can suspend.
No. This is with regard to suspension, with regard that is putting the firm on a holiday.
Yes. You see, your lordship, that is why I was equating this with a disciplinary proceeding. Now, once a disciplinary proceeding is initiated, it can be for a major penalty or a minor penalty. The person can be, delinquent employee can be dismissed from service. But during the inquiry, we can always suspend him from rendering service. This is exactly the power that we have invoked.
What? Come to the page 65 of the
yes. Page
65.
Yes.
7.0.
This is exactly.
So what you have
suspension.
What you have said is in 8.0 that an inquiry shall be conducted by the ONGC.
Yes.
Correct.
Yes.
And prior to that 710, you put the firm under provisional suspension for 6 months.
Yes.
You have already imposed the minimum punishment.
No, that is not a
already imposed the minimum punishment.
No, it is not a punishment, man. Your lordship will kindly come back to the materials management.
Not, I'm saying punishment, but you have already imposed the minimum period of holiday because it says 6 to 3 years. 6 months to 3 years.
If your lordship will kindly come back to that, my lord, the materials management, that is what it says, my lord. If your lordship will kindly come to that 2.2. 1.2.2. Following are the grounds on which provisional suspension of business dealings, pending inquiry for banning of business dealings with firms shall be done. That is fraudulent activity, etc. Above that, subclause 3, your lordship will see, in case firm commits any of the following, provisional suspension can be for a minimum of 6 months and maximum of 3 years. And the heading itself makes it very clear.
No. In 3, in case firm commits any of the following, fraudulent, this thing, whatever. Then the minimum is 6 months, maximum of 3 years.
Even provisional banning, we can resort to minimum. If your lordship first comes to para 1, clause 1 of that, this policy for banning, heading your lordship will see, policy for banning stroke provisional suspension of business dealings with erring firms. And it is under this heading that then 1.1, grounds on which business dealings with firms can be banned. If your lordship now turns to first, let us come back to first 1.2.1.
Yes.
In the event of any of the grounds mentioned in 1.1 and oblique or 1.2.2 below is noticed against the firm during the tender process or after award of contract, and ONGC intends to initiate banning of business dealing against such firm, it may suspend business dealings with the firm pending completion of inquiry contemplated under para 1.3 to 1.8 below. Then comes 1.2.2. Following are the grounds on which provisional suspension of business dealings pending inquiry for banning of business dealings with the firm shall be done. And this reverts us back. 1.2.1 read with 1.2.2 reverts us back to this 6 months and 3 years. It is not that matter. And the mandate of these guidelines is, the word is shall. The logic is very simple. Your lordship is aware of the law pertaining to this banning, etc. Blacklisting. We as a state or an instrumentality of the state, we have the power that we will not deal with this person for XYZ reason. The only thing that requires the law of blacklisting requires is that an opportunity of hearing. The principles of natural justice need to be followed. Here is a case where we have issued a show cause notice on 2 grounds. Because the guideline uses the word shall. As soon as there is any fraudulent activity, we have to terminate under clause 16 of the contract. There also the word used is shall. As a consequence of termination, there are 2 things provided for. One is we can conduct an inquiry, further inquiry, whether he should be banned or not. The second is pending inquiry, provisional suspension. That is what we have done.
Let us read that 1.
I'm sorry.
1.2.2.
1.2.2. Following are the grounds on which provisional suspension of business dealings pending inquiry for banning of business dealings with firm shall be done. And this 1.2.2 is referred to in 1.2.1. In the event of any of the grounds mentioned in 1.1 and oblique or 1.2.2 below is noticed against the firm during tender process or after award of the contract, and ONGC intends to initiate banning of business dealing against such firm, it may suspend business dealings with the firm pending completion of inquiry contemplated under 1.3 to 1.8. So therefore, my lord, what I was submitting is, otherwise, why this provision has been made? Otherwise, we'll have to, although we have terminated because he has committed forgery. Now, if a new tender comes, we have to give him the work. That is why this provision has been incorporated, that even during until his name is cleared, we have been conferred with the power that we may not deal with it till he is clear. That is the logic. So therefore, there is, in any case, my other limb of submission is twofold. All these relevant provisions, the contract itself, this IMM, all of these are suppressed. Now, so my first submission is a preliminary submission that this writ petition deserves to be dismissed only on the ground of suppression. My second limb of submission is that this is only a consequence of termination. That termination has been challenged and your lordship has refused to stay there. It is automatic. The language used is shall. So therefore, my lord, in my respectful submission, my lord, there cannot be any stay of this suspension. Otherwise, what we will be saddled with is, assuming we come, your lordship will just have a look at the nature of the contract. Your lordship will kindly turn to page 5 of the writ petition. Paragraph 3. Even the NIT, etc. has not been issued, but they have made a statement. These are what we are required to maintain the highest levels of safety. Your Lordship hears about all this in the news that there is a fire in so-and-so well, in so-and-so oil field. Your Lordship will kindly have a look at the nature of the work. Towards that, a contract was awarded to the petitioner company on 9/3/22 with the completion period of 24 months for phase 1, that is so-and-so, and 36 months for phase 2. As per the scope of the work for first phase consisted of non-plant building so-and-so, removal of sludge from ponds, etc., and the site grading roads, etc., etc. This is not very important. Then, major works of this phase is construction of 3 numbers of non-plant buildings at GS3 so-and-so, and 2 numbers of non-plant buildings, etc. The phase 2 consists of repairing of oil storage tanks, installation of sprinkling system, foam pourer system. These are all safety measures, Madam. How can we compromise on the safety only because it does not suit the petitioner? Here is a petitioner who has committed a fraud. So therefore, my lord, in my respectful submission, there is no question of any interim order in this one.
You file your affidavit?
Yes.
Lordship, a quick response. I have taken exception to the words used by my learned counsel. Words like suppression should not be used. There was no suppression here. The manual is his property, he can produce. But the point is to defend his case. I think some amount of restraint and respect that is expected. And Lordship, one more thing. So they have a manual which says provisional suspension can be done. But the point is, there are a number of Supreme Court decisions which says, if no suspension, you can do anything, forfeit. Don't issue me a tender document on the ground that there's inquiry going on. And in their suspension order also, they say that we are constituting an inquiry. An inquiry will be constituted. So to link it with the first show cause notice is really ridiculous. And Lordship will find this manual cannot override the law laid down by the highest court of the country. Supreme Court has clearly said, no blacklisting without a show cause notice. In view of this, my respectful submission, let him file, let him come up tomorrow with it. Affidavit is quite well versed. And then I will then decide the matter. At least till such period, this has to be stayed. I'm being stigmatized.
You have been issued a show cause.
Lordship?
You have been issued a show cause.
No, Lordship.
No, in the termination order also.
No, Lordship.
The show cause is there.
No, Lordship will look at the this order, the suspension order. Whereas mentioned in this
When
form,
can you file your affidavit?
10 days time.
Hmm?
Over 10 days.
10 days time. Okay.
Lordship, an inquiry shall be conducted by the ONDC. That they have not at page 65. They have clearly said what is the linking to the first so called.
No, pending inquiry we have suspended.
Inquiry shall be conducted.
Yes.
So to issue conduct an inquiry, a show cause has to be issued.
MS M. Hazarika, and Senior Counsel. Assisted by MS.
Yes, they were your lord.
S. Dewar, Learned Counsel for the S. Newa, Learned Counsel for the issue notice. Sky Chowdhury, Learned Senior Counsel, assisted by Mr. R. Chauhan, Learned Counsel, enters appearance on behalf of all the respondents.
All respondents.
All the respondents and prays for 10 days time to file affidavit. Praise the Lord. This town. 10 days will be how, which date?
Who will start Lordship? It has to be after.
7th.
7th, before Bihu.
7th, my lord, I am in Itanagar. Can it be on 9th?
Okay. Okay. 9th, okay.
Lordship till such time, Lordship. Only the suspend period of suspension.
Not the provision suspension.
Lordship?
No. I'm still not satisfied. Let it come up. 9th.
But Lordship, they can override even the law of the land.
No. It's not an issue of that. We'll see what happens and then we'll pass over this.
Because even the termination is subject to your Lordship scrutiny. Termination may also go. This may also go. Then what happens?
We'll set you back.
But the stigma, it remains.
There's no stigma.
Right.
After 5 minutes.
May I please, Lordship?
pursuant to an NIT in 2018, my lord, page 17, my lord. My lord, it was for a period of 7 years. Lordship will find, my lord, at the first paragraph, page 17. My lord, NIT was for a period of 7 years, for settlement of 7 years, my lord. Now, petitioner, my lord, emerges the highest bidder, my lord, valid bidder. And my lord, but there was some, my lord, political interference, and then, my lord, he had to approach this honorable court, as the, my lord, settlement itself was, my lord, sought to be cancelled. Then, my lord, he approached this honorable court, and, my lord, during the pendency of the writ petition, he was settled with the fishery, my lord. By order, my lord, at page, my lord, 28, my lord, decision was taken, my lord. And extra 6, page 28, my lord. But while, my lord, granting the, my lord, settlement, my lord, instead of 7 years, my lord, lordship will find the first paragraph, last 3 lines, my lord. Instead of 7 years, my lord, 6 years was granted, my lord. And, my lord, it was held, my lord, that with regard to the extension of the 7th year, my lord, it will be considered a later stage, my lord.
Where is that?
My lord, last line of the first paragraph, my lord. Last 2 lines. At the time of floating of the tender, it was mentioned for 7 years. Therefore, the matter of extension for 1 year would be considered a later stage.
Okay.
Now, my lord, I have been, my lord, running the fishery, my lord, and the 6th year, my lord, ends on 31st of this month, my lord. And, my lord, I have been paying all the KISS money, my lord, at age annexure rate, page 35. I've given a chart, my lord. I've been paying it all through, my lord. I have also an earnest deposit of 8 lakhs and odd, my lord, which is still there, my lord. Now, my lord, since, my lord, the time was expiring, my lord, I filed a representation at page 35, my lord. In the meantime, my lord, I had paid for the entire KISS money during the corona period also, for which I could not, operate the fishery, but I had paid the entire KISS money, my lord. Therefore, my lord, I submitted a representation at page 35, my lord, for extension of the period, my lord. In terms of, my lord, the 1 year, my lord, that was left out, I also paid, my lord, for extension for the period of corona also, my lord. So, my lord, that representation not being disposed of, lordship will find my prayers at page 37 of the said representation. One is, my lord, 1 year for with regard to, my lord, that 16/9/2019 order, which I had shown, my lord, 1 year was left, my lord, kept, my lord, we considered later on, my lord. And of course, my lord, with the prayer for, my lord, that are losses suffering during the corona, my lord, period. Then, my lord, page 38, my lord, since it was not disposed of, my lord, I had submitted another representation, my lord, for disposal of the, my lord, my prayer, my lord. But nothing has been done, my lord. In the meanwhile, my lord, a fresh NIT has been issued, which is being opened, my lord, page 40, for another 7 years, my lord, including the, I'm only considering one fishery, Doloni fishery, my lord. On, my lord, 28/3/2025, my lord, is the date of opening, my lord. And, my lord, my fishery, the fishery with which I am concerned, my lord, is at seal number 12 at page 41. So, my lord, my prayer for 1 year is pending, my lord. And, my lord, if this, my lord, NIT, my lord, seeks to, my lord, settle this fishery once again for another period of 7 years, my lord. Now, my lord, that's why before lordship, my lord, we can, lordship can direct us. We will dispose of by tomorrow, lordship. The tender is on 28. It's a corporation. We can dispose of immediately, lordship. Some department, lord.
You can dispose of it tomorrow.
Or if we get the certified copy, that we can dispose it by tomorrow. Before opening, it is on 28, lordship. We'll not interfere. We are not interfering with. Yes, it's true, lordship. There is a representation is also there. The settlement there is.
When the settlement was made, it was made for 6 years.
Yes, 6
And then they said that 1 year would be considered later on.
That consideration was not there. It is true.
That is correct. That you
correct,
couldn't have
lordship.
done without considering the.
Yeah, we are considering, lordship. We'll dispose it by tomorrow, lord. It is corporation. No approval is necessary, lord.
Okay.
No approval. It is not department, lord. So I assure that, lordship, before going for tender, we'll not.
When is the tender?
20th is the last date of opening, my lord. Page, my lord. Lordship will find it page 40, my lord. Second paragraph, my lord, about 5 lines from the bottom, my lord. The quotation will be accepted till, my lord, from 12/3/2025 to 20/3/2025, and the tender will be opened on 28/3/2025, my lord. We'll consider of staying there. And the settlement will be considered from 1/4/2025. If we consider his prayer, lordship, we'll recall the tender also, lord.
So far as this.
This Doloni, only we are considering this, my lord.
He is a case lawyer. I have one student.
Then should he dispose of this?
My lord, I don't know what order they will pass. So, my friend has said it will be considered, my lord, but then what comes?
I'm not saying that it will be considered. He has a case lawyer. It will be
Therefore, my lord,
considered on merit. I am not saying
my
it will be
prayer,
given.
my
lawyer.
prayer, lordship will issue notice, my lord, but let them go, my lord, if they.
No, 1 minute. If we issue notice,
My lord,
the tender notice will be opened on 31st.
let them not finalize it, my lord.
Then
Let them not finalize, let them dispose of my.
Let us do one thing.
My lord,
I'll pass an order
my lord,
directing them to dispose of your representation by tomorrow.
my lord,
Then we'll list it on Friday
my lord, my
and see
lord,
what happens.
my lord, my lord.
in that case, he is in a benefited position, lordship. Dispose it also, lord. Because we are not, lordship, my recorded lordship, we are not going for we are not going for tender without disposing their application. If any way, it hampers all.
So let it come day after tomorrow, ma'am. Okay. Lordship will pass this
Mr.
order.
M. Datta and a conflict of petition. Stop. Para- The petitioner was settled for
Doloni fishery, madam, Doloni fishery. Doloni mean ball Bongaigaon, madam.
in respect of the Doloni Min Mahal, Bongaigaon, by an order dated 16 to 2019. Stop. In the said order, it is stated that at the time of floating tender for Min Mahal, it was mentioned for 7 years. Thereafter, the matter of extension of 1 year would be considered at a later stage. Stop. When was your fishery handed over?
It was handed over, my lord. On my lord, from 1/4/19, my lord. Page
The said fishery in question was handed over to the petitioner on
my lord, from 1/4/19, my lord.
from 1/4/2019. And since then, the petitioner is running the said fishery till date. Stop. After the expiry of 6 years, prior to the expiry of 6 years, comma, the petitioner made a representation before the managing director, Assam Fisheries Development Corporation Limited, on 18/5/2024, with a request for settlement of the Doloni fishery under Bongaigaon district for another 1 year from 31/3/2005 in view of the settlement order dated 16 to 2019 and with a further period for extension of the settlement period by another 2 years, considering the loss suffered by the petitioner during the COVID pandemic. Stop. However, comma, as no steps were taken, the petitioner filed filed a reminder. Another representation on 10/2/2025 before the director of Assam Fisheries Development Corporation Limited with a request for extension of 1 year as mentioned in the allotment order dated
16 to 19.
16 to 2019. Stop. In the meantime, comma, The Managing Director, Assam Fisheries Development Corporation Limited, floated tender inviting notice number 1/2025, wherein it is stated that the quotation will be accepted up to 28/3/2025, and the tender will be opened on 28/3/2025. Stop. Voila. The petitioner being aggrieved with the issuance of the notice, tender inviting notice dated
11/3/25.
11/3/2025 is before this court on the ground that the representation made by the petitioner on 16 to 2019. No,
No,
on
18/5/24. 18/5/24.
18/5/2024 and 10 to 2025 for extension of his settlement of the Doloni fishery under Bongam district has not been considered, and the respondents have proceeded with the NIT. So, voila. Mr. P. Sharma, understanding counsel Fisheries Department, at this stage submits that the representation dated 18/5/2024 and 10 to 2025 would be considered by the respondents on or before 27th of March 2025. And only thereafter they would proceed with the opening of the tender notice. Tender notice dated
11/3/25.
In that view of the matter, the list the matter on 28th of March 2025. In the meantime, which responded?
The managing director.
Managing director.
Respondent number?
Respondent number 2, madam.
The respondent number 2 / Managing Director, Assam Fisheries Development Corporation Limited, shall dispose of the representation before on or before 27th of March.
They have to give a certified copy.
No, you instruct your department. If they go with the certified copy, it will take time.
Because tomorrow.
Mr. P. Shamal and the Standing Council Fisheries Department shall accordingly communicate this direction to the respond number 2 within the course of to respond number 3 within the course of the day.
May I get that copy of this order and to communicate.
Registrar is also directed to furnish a copy of this order to Mr. P. Sharma. Then so to do the next.
Deeply obliged, Lordship.
Highly obliged.
68.
Lordship, I have been affected with the annexer 6, page 39. That annexer 9, annexer 6. The date of opening is on 27/3/2025 and issue was 1/17/2025. That means tomorrow, your Lordship. Now here there is a condition at page 48. Terms and condition, your Lordship.
This is a big document, isn't it?
Yes, Lordship. Only one point I have to come with a small pair. That there is an experience for consecutively for 5 years. 68 consecutively for 48 pages, your Lordship.
Yes.
It is an eligibility criteria. It has been mentioned, your Lordship. My Lordship, page 48, para number B4. The farm company agencies should preferably have experience of providing similar service during the last 5 years in state, central government run hospitals, CSC, PSC, as experience certificate is to be submitted along with the bid. That is also is okay, your Lordship. Then thereafter, your Lordship,
in the seventh page, 7 column, the bidder should have experience of executing similar service in one single work value of amount indicated in the tax-based ATC or 2 work order value last 2 financial years as indicated in the tax-based ATC of bid document, supporting work order and completion certificate to be submitted along with it. Here in this case, Your Lordship, the Huzai, I'm pertaining to Huzai district, Your Lordship. The Huzai district has been newly districted on 2017.
When was the NIT issued?
NIT has issued 17, only 10 days, Your Lordship. 17/3/2023-25, Annexure 6, page 39.
Okay.
And they are supposed to be closed on tomorrow, Your Lordship, 27/3/2025. Now, issue remains is that, Your Lordship, that continuously for 5 years, around the turnover is around 150 lakhs. In the pace, in minimum average turnover of the bidder is for last 3 years, it should be 150 lakhs. In a district like Huzai, after COVID, if you calculate, Your Lordship, for 5 years also, it will not be counted around.
What is the tender for?
Tender for the kitchen and dietary products, Your Lordship, for inter running to the hospital, supply to the hospital.
Okay.
That is there, the terms and conditions have been mentioned in the page 45, Your Lordship, health, kitchen and dietary services. These are the conditions, Your Lordship. Now, issue remains is that, Your Lordship, initially I was having tendered by the department, health department, that is on page 28, Your Lordship. 70/2024, I have been direct, this is the NIT, Your Lordship, whereby I have been participated with all conditions, Your Lordship. After being satisfied all the things here, so Annexure 3, Your Lordship, page 32. The Joint Director has issued me the contractual works for appropriates of procurement of dietary proteins health institutions under Huzai district. Thereafter, Your Lordship, Annexure 4, page 37. After being supplied and contracted for the executing for the 2 years, Annexure 4, they have cancelled my tender process, my contractual work. In compliance of the directive of the Director of Health Service, so and so, the tender for dietary articles for defined health systems under joint DSS Huzai district, which was previously approved by you, now hereby cancelled due to some inadvertent circumstances. Without any being reason, they have cancelled it. Then surprisingly, Your Lordship, then page 38. Then they have mentioned the director has instigated there with reference to the subject matter, you are hereby requested to process the diet with effect from 1/4/2024 to 25/6/2024 for payment, the residual amount which I supposed to be getting. Thereafter, Your Lordship, regarding continuation of supply of dietary articles, you are directed to manage the supply of dietary articles with 25/6/2024 by the earlier approval, Lordship. Diet supplier farm by Messrs. Arfrin Collection, Nagaon until the final issue. They are doing this pick and choose policy, Your Lordship. Earlier it has been tendered me, then cancelled, then earlier one, I don't know who is there, without any mention, in advertised circumstances, they have supplied to Arfrin. Then till final subjected case. Now thereafter, Your Lordship, they have issued this tender without settlement my agreement. I have executed for 2 years. And I have paid the money, and that amount total around 15 lakhs have been till now in the department.
But that cancellation you have not challenged.
I have challenged, Your Lordship, right now. Thereafter, you have challenged this.
In this writ petition?
Yes, I have challenged. I have challenged. Thereafter, I came to know that on 17/3, then I make a representation on 18/3 with hurriedly. Then I have an objection regarding on this tender process because since I have been already been executed.
Where's your representation?
Annexure 7, page 55. This is the data. After being procured for 3 months, Your Lordship, I have paid the amount, I have invested my money. Without any circumstances, they have cancelled my contractual work. Now, only to behave of the Arfrin Collection and other parties, which is around to be 125 lakhs rupees.
See, Gogoi, the termination order which was issued in June 2024, you are challenging today.
I'm repeatedly went to the department here.
That is a different issue. You are challenging only today, after the NIT has been issued.
Only what
After the NIT has been issued, you are challenging your termination that was passed in June 2024.
Lordship. I supposed to be participate in the tender process in spite of all my maids and demerits. Only point is that if it is been not been last continuously be dropped out only for expenses for 5 years, then it is I can participate.
Now, how does this court interfere with the tender conditions?
Now the issue is means I have no any other remedy, Your Lordship. I have to come before this honorable court with my all remedy.
Yes, go.
So for example, the earlier cancellation, as Lordship has already stated, it is of 2024. So he has accepted that cancellation without any demand, because there is no representation to that effect that it should not have been done. Now, my lord, when this new tender has been plotted, he is only agreed by 2 conditions regarding that 5 years experience. But regarding challenging my lord's tender conditions, my lord, the law is well settled, my lord. Right from my lord, Michigan river and rubber and all, my lord. That is up to the tendering authority or the employer who will, my lord, place the, my lord, tender conditions up to their requirement.
Who knows what's best for
Yes, and my lord, so far as this particular bid is concerned, it is for, my lord, any, my lord, firm who is within the state, they can participate. But it's not that, my lord, is limited to the petitioner. So if others are coming, my lord, can, my lord, just because the petitioner doesn't fulfill this particular tender, whether it can be interfered with, my lord.
Yes.
We'll have to show some authority, my lord, that will, Lordship, as per his terms and conditions, not as per the employer.
Before issuing the NIT, basically the joint director is responsible for each districts. Now this is the first time, Your Lordship, the director has instigated to the joint director to cancel my my tender process, and now we instigated to open up in entire Assam.
That challenge is too late. That challenge to your termination is too late.
Lordship. Otherwise,
Number 2, the NIT conditions that the user or that the department has put. Now it is up to them. They know best what conditions is required. How can this court interfere in those conditions unless you show that there's something arbitrary?
Lordship, I have mentioned in my petition that 2007 is segregated as a separate district. If you, Lordship, perused if you verification of the records from the joint director is the sole responsible for the district, and he has communicated to the director. Now the joint director has to give them reply on that condition that in the amount which is supposed to be turnover 135 lakhs per month, 1 crore 35 lakhs, whether it's to be sustainable or not in the district. Because initially the tender which has been issued by the joint directors, not by the directors.
Are the tenders confined only to Hojai district or all of us?
Entire Assam, Your Lordship. But in my case in hand, Your Lordship, so far I am the intender of this contractor. I only pay that if it is deleted the continuation 5 years. If Lordship permit me, the COVID is 2019. Consecutively for 5 years for specific of this type of contractual works, there ought to be justified on that point of view also. It is only for the BS of the sum of the contractors, Your Lordship.
I'm not going into your termination. I'm on the NIT.
No, I'm telling about the NIT. Only the NIT which have been done only on the basis of the sum of the directors, some of the contractors.
You give me a good reason why I should interfere with
That
the
is the
terms
part
and
of
conditions.
no, Lordship, the good reason I have given Afrin collection is the one part. I have been cancelled. Okay, Lordship, I have not been justified before this honorable court to be presumed to be argued matter. Who is the other person that Afrin has been got the collections, had been tender process? What is the answer of that department, Your Lordship?
You've not challenged that also.
No, that is the way I have been challenged here. Whatever the order have been there, I have been there, Your Lordship. I have been mentioned.
And how do you know that this work will be given to that particular Afrin? They've called for an open tender, inviting tenderers to participate in the tender process, giving certain conditions. Now, when other tenderers are able to comply with the directions, you just can't comply with 1 or 2 conditions. You come to court challenging those 2 conditions. That is not permissible.
Lordship, my humble submission is although there is
give a good reason how this court can interfere with the conditions in the NID.
The NIT only one point is I am coming with a very small pair that due continuous period. If Lordship may cut off that during last continuous to word, then I can participate today itself.
How can I do?
Now, point is that, Your Lordship, I have already about a settled Tata Cellular case also in the NIT, no interference. But the thing is that only BS of the sum of the respondents. It have been done, Your Lordship. It is a clear fact, but although it is not in merit in my case, but I have mentioned that The reason for cancellation of my tender process have not been mentioned. Let me show that due to the inadvertent circumstances. What is the inadvertent circumstances? What is the follow to me? Give me the reply, Your Lordship. No, nothing.
Lordship will issue notice without any stay. That will reply. Why is cancellation was made? That is
Only point is that I
No,
maybe
that cancellation part, I'm not going into it. It's too late.
too late.
and my
You're challenging your cancellation after the NIT.
one is to recover my area deposits amounts. I'm not even I'm in doldrum situation where my amount will be paid or not, Your Lordship, because the amount around 11 lakhs more than I'm a petty worker. I'm a contractor. I've not been paid. Till now, I'm in door to door. I've been there. Now I've been challenged on the part that I came to know that. So I also want to intending to participate. May Lordship may seek in a holistic approach, Your Lordship, in that point of view. Only for the BS of the sum of the respondents only.
Okay, we can consider a prayer for payment of your outstanding bills. Rest difficult.
This has happened with the entire Assam, Your Lordship. This is not a case of an ideal example of Your Lordship.
That I don't. As a court, I can't go into all those.
I have nothing to say, Lordship, because I want to participate in the tender process, otherwise.
Okay. Okay, we'll give a direction to clear your outstanding dues. The rest dismiss.
The next case is also same, Your Lordship.
Only
Yeah,
that
also-
cancellation part is not there. The only tender condition. So that also will not succeed.
This also case, same case also only on the part of the tender process, Your Lordship.
Like,
Deep levels.
14 of daily list.
But I have made a statement in paragraph 11 and 17 that the co-district commissioner is hereby not taking coercive action against the petitioner, and
okay,
I have made an application before the concerned authority. They have not handed over the possession of the fishery to me.
where's the settlement order?
At page 23. At clause 3, it says that if I fail to pay the revenue, then it shall be recovered as area of land revenue.
No, then, but then you have not been handed over the fishery.
No, I have not been handed over the fishery. That
So
is
where's
my
the question of paying
that
the
is my
fees?
categorical assertion, and I have been repeatedly representing the
Sharma?
authorities.
What can I do? We can go for representation, Lordship.
That's the whole thing.
And
Heard
in the meantime,
protest.
they shall not take any coercive measure.
Learned counsel for the petition. Stop. Also heard Mr. P. Sharma, learned standing counsel, Fishery Department for the respondents. 1, 2,
1, 2, 3, 4.
1, 2, 3, 4. And Mr. J. Bokalia, learned government advocate for the
1, 2, 3,
respondent.
4, 8 is also I am. 8 is also.
8, huh? 1, 2, 3, 4, and 8. For the respondent, J. Bokalia, learned government advocate for the respondents. 5 and
5, 6.
5, 6, and 7. Stop. The petitioner was issued a settlement order by the subdivisional officer within bracket C. On 12/9/2023. In respect of 1/51, Vijaya Fishery in Bongaigon district for a period of 3 years, from 7/8/2023 to 6/8/2026. Stop. On payment of annual sum of rupees 12,13,524. Stop. Thereafter, the subdivisional officer, North Salmara, by communication dated 12 September 2023, issued to the petitioner, directed to deposit an annual sum of rupees 12,13,534. Along with an amount of rupees 66,963 as security deposits within 2 days. Stop. You deposited those amounts?
I have deposited around 2 lakhs, that amount I have deposited, my lord.
Okay. However,
2,66,000 I have deposited.
despite settlement of the said fishery in question, the fishery was not handed over to the petitioner till date. Has not been handed over to the petitioner till date. Stop. Accordingly, the petitioner made a representation on 18/3/2025, correct?
Yes, my lord.
Before the Secretary, Fishery Department, Government of Assam, praying for handing over 1/51 Koya Puja fishery to the petitioner. Stop. The grievance of the petitioner before this court is that despite the representation dated 18/3/2025 made by the petitioner, the same is yet to be considered and disposed of. Stop. Para. Mr. P. Sharma, understanding Council Fishery Department submits that the direction can be issued to the respondent. Who is the secretary?
Commissioner Secretary, my lord.
To the respondent number 1, Commissioner Secretary, Fishery Department, to dispose of the representation dated 18/3/2025 made by the petition. Stop. Para. According to this petition is disposed of. Directing the respondent number 1 to consider and dispose of the representation made by the petitioner on 18/3/2025 within a period of 2 weeks, 2 weeks from the date of receipt of a certified copy of the order of this court. Stop. The outcome of such consideration shall also be indicated to the petition. With the above observations and directions, with petition is disposed of. Till the representation is disposed of by the respondent number 1 on top of, no coercive steps shall be taken against the petition.
There is a minor thing, it should, that's enormous secretary, additional chief secretary, should be written additional chief secretary.
But here is Commissioner Secretary.
Commissioner secretary, I written. Enormous secretary is the additional chief secretary. Otherwise, joint secretary is also there. Commissioner secretary as a name.
Commissioner Secretary is
Yes,
there.
he is there, he is there. And if the petitioner is given a opportunity of personal hearing, what do you?
While considering the representation made by the petitioner, the respondent number 1 shall also afford an opportunity of hearing to the petition.
Just
In
let
person.
it be 3 weeks, lordship.
3 weeks, sir.
Much obliged. Highly obliged.
21, impleadment of party.
Lordship, during pendency of this contempt petition, your lordship, Commissioner Secretary has changed your lordship, and in this, in her place, present opposite party has taken over the chair as Commissioner Secretary.
Who's the present secretary?
Commissioner, your lordship, opposite party, your lordship. I have communicated the order also, your lordship, on 6.
Commissioner Panchayat RD, this Srimati Kriti Jali.
Yes, yes, your
Heard Mr. K. Miral and a contributor applicant. By this application, the applicant who is the petitioner in contempt case number
242.
242 of 2023 is praying for impleadment of page 3, A to A. As party respondent number
7.
7 in the said contempt petition, on the ground that the proposed respondent is presently holding the post of Commissioner, Panchayat and Rural Development Department of Stop. This court, on consideration of the question in the present application, the prayer for is satisfied and the prayer for impleadment is allowed. Stop. In the contempt, in view of the order passed today, so let's so and so be impleaded as party respondent number
7.
no. 7 in the present contempt petition. Issue notice to the newly implemented respondent number. No, on top, petitioner shall file an amended cost title within a period of 1 week. Issue notice to the newly implemented respondent number 7. Petitioner to take steps for service of notice on respondent number 7 by registered proceeding within 1 week, at least up to 4 weeks.
70 and 71 of supplementary list. Stay back.
My lord, we have filed an IA in this case. Now, the facts are like this, my lord. Indian Oil Corporation Limited, BRPL, it's a Bongaigaon refinery, my lord. They have a guest house in Guwahati. For that guest house, my lord, for the catering, to provide catering service to the guest house at Guwahati, an NIT was issued sometimes in, my lord, 24/3/2023. Now it was for a period of 2 years. Now, my lord, the writ petitioner, he was awarded the catering contract. He started the catering work from April. He did till month of May. Thereafter, my lord, on the ground that the the contract laborers were there, were engaged by the earlier caterer. Therefore, he would like to engage his own person. So a dispute arose, my lord. Then he initially, my lord, he withdrew from the contract. Then eventually we terminated the contract. Now the period was up to my lord 24th of March 2025. Initial period. Now, my lord, that cancellation of the contract was challenged before the learned single judge. That was upheld. The challenge was upheld. It was said that cancellation was bad, etc. But in the meantime, my lord, the period was also coming to an end. Now, against the order of the learned single judge by which the termination was held to be bad, the contract laborers filed a writ appeal. Now, the writ appeal, my lord, was also eventually rendered as infructuous because in the meantime, the period of 2 years expired. In the meantime, my lord, BRPL authority issued a fresh tender in which the writ petitioner has not participated. Now, that tender is under challenge in the present writ petition. Now, the question is, my lord, whether he has a right to perform the contract for a period of 2 years. That will be decided in the writ petition, which is presently pending in 6142, where 6142 of 24, where a decision of the authority that he cannot operate beyond the original contractual period is under challenge. Now, my lord, an impugn NIT was issued on 1/2/25. Now, this NIT has been challenged in this present case where there is a stay order. Now, the fact that he has not participated in the tender process, what is his right, my lord? If he succeeds in WPC number 6142 of 24, which is pending, based on that, if he institutes a civil court for damages and all, that's a different issue. But how can he stall the contract, my lord? So my prayer is, we should be allowed to go ahead with the contract. That is why we have filed the IA. Once he has not participated in the tender, what is locus standi to challenge the
Where's the interim order?
Yes, at page number 15.
And the operative portion is at Millard, page 18. In the interim, tender process initiated by NIT details shall not be finalized without leave of this court till the next date fixed. And then we have processed the tender, now we would like to settle the contract. That is how we have filed the I. Now, because he has not participated in the tender process, what is his right to challenge the NIT? Yes, he has a claim to perform the earlier contract. Now that period is over. Now, if you succeed in the writ petition where you have challenged that order, that's a different issue. But what is your right? That is the only, and therefore my humble submission is, my lord, we should be allowed to go ahead with the tender. And regarding his other claim, my lord, that will be decided in WPC 614/24. That is my case, our case.
My lord, may kindly come to the writ petition 738 at page 25, man. That's the operative portion of the judgment and order. Does my lord have it? Yes. At page 25, yes. At para 17, my lord, what this High Court says, what this Honorable Court says, in view of the aforesaid facts and circumstances, this court is of the opinion that a case for interference is made out. Accordingly, the termination order dated 6/11/2023 is interfered with. Consequently, the respondent refinery is directed to allow the petitioner to complete the contractual liabilities in terms of the work order dated 29/3/2023. It is also made clear that the respondent refinery cannot restrain the petitioner from engaging its own men for discharge of the duties. Since the contract was for 2 years, and because of the issues involved, the petitioner could not discharge the same. The petitioner would have the liberty to file application for allowing to discharge the functions for the full term. In case such application is made, the same would be considered by the respondent refinery in accordance with law and by passing of a speaking order. Both these writ petitions are accordingly stand allowed. Now, my lord, from 17 and 18, it is apparent that the breach of contract happened. The breach was committed by the IOC.
What 17 and 18?
Para 17 and 18 of the judgment and order, in the writ petition of the learned single judge of this High Court, my lord. The termination order was set aside and we are asked to perform a contract and specifically asked them not to restrain us from employing, because as per clause 2.2.1, we have to employ our own workforce. They did not allow us. They said, we have some contractual laborers with us. They will work, not your people. So we came to the court when we said that we have invested time and money. We have taken loans to employ 27 numbers of skilled workers for this work. So we may be allowed to work with our own workers. So the court allowed us, and they told them specifically not to restrain us. And since the breach was committed on their part, this honorable court allowed us to work for another 2 years, the full contract term.
Let us see.
That is at para 18, my lord. Since the contract was for 2 years, and because of the issues involved, the petitioner could not discharge the same. The petitioner would have the liberty to file application for allowing them to discharge the functions for the full term, and in case such application is made, the same would be considered by the respondent refinery in accordance with law and by passing of a speaking order.
So did you make the application?
Yes, ma'am. I'll come to that, ma'am. Now, they have not challenged this before the division bench, the respondent IOC. So this order is the law now. It is final. Now, my lord, may kindly come to page 31. This is analogous writ petition listed today. This is 6142 of 2024. Page 31 is the order. Does my lord have it? Page 31. So here, issue notice making it returnable on 16/12/2024. When we made the application, my lord, before the respondent IOC authorities, they said no, we'll only give you 6 months, not 2 years. You either work for 6 months or you go. So we came to the court again. This order, issue notice making it returnable on
that order passed by the IOC?
That is, my lord.
In IA 37 page number, speaking order. 37 in IA. No, I.
In the IA.
Yes.
Even in the writ petition, my lord.
Oh, you have annexed?
The annexure 3 at page 28 of my writ petition, my lord, page
Okay.
738. I mean, writ petition 738, annexure 3, page 28. So here they dispose of her without any application of mine, without adhering to the principles of natural justice. Arbitrarily, they said, no, we'll only give you 6 months, we'll not give you 2 years. At the same time, they have not appealed before the division bench against this order. So, my lord, at page 31, my,
What is this writ appeal?
my lord,
Page 29. The last third para.
the writ appeal, that what my learned friend had just mentioned, that was, they had, this contractual workers, they said that, no, we have an agreement with IOC, so we have to work irrespective of the contractor, will always work here. So they went to the contextual workers, went to the division bench. The division bench said, no, you go to the approved authorities. Why have you come here? So that was disposed of without any order. The learned division bench refused to interfere with the order of the learned single judge, allowing us that restoring us the contract in our favor. Now, since they said, no, you go away, we'll give you only 6 months, arbitrarily they just pushed us away. So we again came to the court by filing writ petition 6142 at page 31. This is the order. Issue notice making it returnable on 6/12/2024. The petition is directed to take steps upon respondent by way of number 1 to 5 by way of registered post with AD as well as by usual process in 3 days. In addition to that, the petitioner is also given the liberty to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner was issued a work order on 29/3/2023 for providing catering and other services in the BGR Guwahati Guest House and Office Complex for a period of 2 years from the date of handing of the site. As the respondent did not hand over and subsequently terminated the contract on 6/11/2023, the petitioner filed 2 writ petitions before this court challenging the inaction as well as termination being WPC number so and so respectively. Both these writ petitions were disposed of by judgment dated 6/9/2024 by the coordinate bench of this court with the following observations. Paragraph 17 and 18 of the said judgment being relevant in this is reproduced herein below. So again, 17 and 18, the Honorable Court has quoted. Pursuant to the said observations, the petitioners have submitted an application in terms with the liberty so provided requesting the respondents to allow the petitioner the full term for which the contract was awarded to the petitioner. However, at para 5, page 33, however, the speaking order dated 22/10/2024, the respondents, though agreed to hand over the site, but limited the period only up to 30/4/2025, that too making it subject to the outcome of writ appeal filed by one Dilip Kumar Sharma and others. 6, Mr. R. Sharma, the learned senior counsel appearing on behalf of the petitioner, submits that perusal of the direction passed in the judgment and order dated 6/9/24, which showed that this court had categorically permitted the petitioner to file an application for allowing to discharge the functions for a full term, that is 2 years. However, by the impugned order without assigning any reasons, the contract period was truncated only up to 30/4/2025. Mr. R. Sharma, Dalal Senior Counsel, therefore, submitted that the said order dated 22/10/2024 suffers from complete non-application of mine. The respondents are directed to bring on record the stand by filing an affidavit on or before the next date, list accordingly. Now, my lord, this is sub judice. If my lord,
so whatever it is, right along, your contract continues out to 34/2025.
Yes. So which were not agreeable. So you have,
as per the terms of the ONGC.
As or the Indian Oil Corporation, my lord. So, my lord, 6142 is pending. There we should now. They have not appealed this judgment and order before the division bench. Shouldn't they have come to the court and taken leave of the court before issuing a fresh tender? Because my contract is subsisting. The Honorable Court has restored my contract. Their job is to allow us to work. They are trying to subvert the court order, the law of the land, by saying that, no, we have issued that. Why should I bid for a fresh tender when my work is already in progress? I've not been allowed to work. That is a different matter. But since the court has restored my contract, the only way for them is to appeal to the division bench and get an order setting aside the order of the learned single judge. They are not doing that. Now, if my lord intends to vacate the stay order, what is the outcome? Number one, this judgment and order dated 6/9/2024 will be rendered redundant. It will go away. The law will be just subverted. Number two, it will give rise to multiplicity of proceedings, because if fresh bidders come in, the new fresh rights will accrue to them also. Number three, my lord, where is the principles of natural justice? They are not interested in courts. Let the courts pass what orders they like. We'll do what we like. That is the attitude. Can an instrumentality of a state have this kind of an attitude by subverting the decision of the honorable court? My humble submission is, my lord, let this, because we are also tired of this litigation, my lord. 2 years. We are all simple contractors. Where will you go, my lord? Let this matter come up next week, on 8th of April, or right after BU vacations. Let these 2 writ petitions be finally heard, because this will render 6142 also. The writ petition we had filed, which is pending, this analogous matter.
That is challenging the NIT.
This is one, and challenging the denial of my contract for another 2 years.
So no, that this 738 is for denial of 2 years.
No, 738 is for challenging the fresh NIT, and 6142, the second matter is for denying me the contract for another 2 years. 6142, my lord. That is the second matter.
Ah, 6142 is 2 years.
2 years, my lord. So, my lord, that will also be rendered infructuous. And if a new tender is opened, the bidding process starts, then new rights will accrue to the other bidders also. Then where will you go?
We have an urgency in this matter. Lordship, at 2, I will produce the copy of writ appeal, Lordship.
What writ appeal?
Lordship, writ appeal against the order.
The single bench.
Yes, Lordship.
It is here, my lord.
And my senior also gave reply, Lordship.
And the division bench, the honorable chief justice specifically asked the IOC, why haven't you filed your own writ appeal? Why are you coming? Because these people and the IOC, they are hand in glove. It is a huge story, my lord, because these people apparently have been.
No, this writ appeal is by those
Contractual workers.
Contractual
IOC
workers.
is nowhere, my lord. They have not appealed against the judgment and order. So they want to place their shoulder on their guns and fire at us.
So writ appeal is over.
Lordship, come to page number 38, Lordship.
Of?
Whereas the above work order communicated on 015/2000.
1 minute.
Lordship, kindly take up at 2, Lordship. My senior will give reply, Lordship. As per acceptance of JAM contract, following the kick-off meeting held on 25/4/2023, Messrs. SH Enterprise have agreed to start the job on 1/5/2023. Lordship, they have already started their contract.
My lord, these are settled issues in the writ petitions, my lord.
Job from
These are settled issues before the other writ petitions.
But
If this interim order is considered,
yes, Lordship.
I think 2 issues are there. One would render that other writ petition that 6142 infructuous.
But mainly the main judgment and order that will be rendered infructuous.
And then the other one would be creating a third party right.
Lordship, but
So what I would suggest, subject to what we can hear and dispose of all these petitions instead of considering your IA on a short date on the next week also.
My lord, next week will not be 8th of April, my lord, Tuesday, my lord.
we have an urgency because Lordship guest.
They waited for 2 years, my lord.
No, Lordship, we have met.
And for 10 days they
Now, what urgency is there?
Lordship, because it's the guest house and all the.
He's running till 34.
No, my lord, the guest house being run by the own people now. Because
No, Lordship.
they've taken permission from the learned singulars, then that let us run it through our own people. So the Honorable Court allowed them.
Lordship give me us permission to give alternative harassment till that.
No, what? No, as per your order,
Yes.
the petition is allowed to run for up to 34/20/25, isn't
Yes,
it?
my lord.
But
Correct.
Yes,
in
my lord.
new tender, they have not participated, so they have no right, Lordship.
Why should he participate when there's a law of the land, when there's a judgment in place?
Why not we dispose of all this with petitions together?
My lord.
No, Lordship, because we have to finalize the tender process.
That's why I'm saying before 34/20/25, at least he's running up to 34/20/25.
My lord.
Right?
As per the order, right or wrong. My lord.
Lordship,
My lord.
Lordship, kindly add two, Lordship.
Okay, if
At
you
two,
want
Lordship,
to, we
at
can
two.
pick up at two. That's no problem. We'll continue at two.
Add two, Lordship.
We
No,
take
Lord-
up the
Lord,
whole.
will you kindly bear with me for 5 minutes. Now, please come to that order by which a speaking order was passed pursuant to the order of the learned single judge, by which, my lord, the termination order was interfered with. That is at page 37.
Of your IA?
Yes.
Hmm.
22nd of October 24. Please come to the last para, because prior to that, my lord, the High Court's order is quoted. Whereas GM contract dated 29/3/03/23 for providing catering and other services in BGR Guwahati Guest House, an office complex at Jayanagar Road, 6 Mile, Guwahati, White work order dated so-and-so, was awarded to SH Enterprise as per terms and conditions of the contract. The duration of the contract is for 2 years from the date of handing over of the site. Whereas the above work order commenced on 1/5/2023 as per acceptance of the GM contract. Following the kickoff meeting held on 25/4/23, Messrs. SH Enterprise have agreed to start the job on 1/5/23 and started execution of the job from 1/5/2023. But SH Enterprise have failed to carry out the job of running the services of the guest house 6 Mile, Guwahati, following which show cause notice has been served to Messrs. SH Enterprise for leaving the work site and failure to carry out the execution of the contract, and subsequently termination notice of the contract was issued on 6/11/23. Being aggrieved with the said termination order, SH Enterprise filed a writ petition before the Honorable Guwahati High Court. Whereas Honorable Guwahati High Court by judgment and order dated 6/9/24 set aside the termination order dated 6/11/23 and allowed Messrs. SH Enterprise to execute the job as per the work order dated so-and-so to complete the contractual liabilities of the contract. Now, therefore, in view of the above, hereby directed to complete the contractual obligation of the contract for the remaining period of the contract up to 34/25, subject to the outcome of the writ appeal filed by Dilip Kumar Sharma and others in the Honorable Guwahati High Court. You are advised to kindly confirm acceptance of the above contract as well as modalities of taking over the site for execution of the contract by completing the required contractual formality. Further, it is to mention that Honorable High Court order will not create any equity in favor of either of the party, nor High Court order will prejudice any party. Now, my lord, initial contract was up to 30th of April 2025. Now, he started operating the contract from 1/5/2023. For sometimes he continued. Then, my lord, what he did, he started paying less to the laborers, contract laborers. Now, these contract laborers are working with us for the last 18 to 20 years. My lord, there is no convention in the system to replace the contract laborers merely because there is a change of contractor. Now, he said, no, I'll take my own man. That was the dispute. Then, my lord, he should not have stopped the work. He stopped the work and left. Then we should show cause notice, then we terminated the contract. Learned single judge says that termination is not correct because there is no express provision in the contract that is bound to take the existing contract laborers. All right, that order stands. Against that, the contract laborers filed a writ appeal. Now, writ appeal was closed because in the meantime, that period was going to be over. But that question of law, whether a new catering contractor is bound to take the old contract laborer, that is an issue which has been left open. Now, my lord, a new tender has been issued on 1st of February 25. We have to conclude it by 30th April. From 1st of May, we have to give it to a new contract. Now, in the ensuing new contract tender, he has not participated. Therefore, what is his right? Assuming for the sake of argument, my lord, that this WPC number 6142 of 24, which is pending against the order dated 22/10/24, which I have read just now, is allowed. Let us assume, my lord, that writ petition is allowed. That speaking order is set aside. Now, what will ensue, my lord? It will give him a cause of action to institute at best a damage suit. Now, can he perform once the contract period is over? That is the issue, my lord. Now, this writ petition, how is it even maintainable? A person has not participated in the tender. How come he can challenge the tender? Now, how can he take somebody else's right? His right is pursuant to the earlier contract to operate it till 34/2025. Nothing beyond it. And this is a tender for the period next to 34/2025. Now, how is aggrieved? Had he been participated for some other reason, he could have challenged. So therefore, my lord, even under the provisions of this Specific Relief Act, he cannot say that I have a right to perform the contract. He cannot have. He can at best, supposing he wins the case, he can file a civil suit claiming damages. Well, nowadays, in contractual matter, the view of the Supreme Court is, even, my lord, Specific Relief Act has been amended in infrastructure projects. Where it involves public interest, courts have been restrained from passing even interim orders. Now, here is a contract which pertains to, my lord, day-to-day necessity of the people who come from different parts of the country and stay there, providing catering services. He has neglected to perform that duty. Maybe he has a right. Let us assume, my lord. The question is, what right he has got to stall a tender process? He can institute a 100 crore damage suit, my lord. He may succeed also. But what right he has got to stall this tender process? Now, can he, without participating in this tender, claim any right to perform? Even the period for which he participated. On 30th April 2025, everything will evaporate. In that view of the matter, my lord, my humble submission is, we will let us proceed with the tender. What right he has got, my lord? End of the day, even if your lordship hears all the matter together, lordship may allow that writ petition. Let us take a hypothetical situation. But lordship cannot allow this writ petition. In this writ petition, on what ground has he challenged, my lord? What is the legal right of the petitioner which has been violated, for which he has challenged the NIT? Can he say that the NIT cannot be issued?
Okay.
That is my humble submission. Therefore, we should be allowed to go ahead with the tender. The other hearing can be expedited. I have got no objection to that. As such, it was filed. It is a matter pending from last year. But to take this matter and to keep this matter pending, it doesn't, justify. That's my whole subject.
Madam, whatever my learned friend has, whatever submissions he has raised, madam, these issues, that speaking order of the IOC, these issues have already been settled by the writ petition 6569 my lord, last year itself. This is the speaking order is at Annex 3, page 28.
Of the IA?
Of my writ petition, my lord, and your lordship may also come to the IA at page 38. There's a, sorry, the 37 Annex E page 13 of the IA.
That would see.
My lord, whereas the, whatever my lord, issues of brevity, I shall not again read it, but whatever they have stated in their reply, rejecting my two full year contract, these issues have already been settled by the learned single judge. That is the law prevailing as on today. That my contract has been, termination has been restored. I am allowed to perform my contract. And most importantly, in para 17 and 18, as I had already submitted before of that order, that is again in IA, my lord.
Page?
Just complete, my lord. At page 36, my lord, of the IA. Para 17 again, para 18, I have already gone through it, my lord, before your lord. In view of the aforesaid circumstance, this court is of the opinion that a case of interference is made out. Accordingly, the termination order dated 6/11/2020 is interfered with. Consequently, respondent refinery is directed to allow the petitioner to complete the contractual liabilities in terms of the work order dated 29/3/2023. It is also made clear that the respondent refinery cannot restrain the petitioner from engaging its own man for discharge of duties. Now, my learned friend on the other side is trying to project that I abandoned the work site and I ran away. It is not that. It is a finding of the learned single judge. It is they who restrain us from performing our part of the contract, but not letting my men and materials go into the kitchen and do my work. Therefore, in 18 again says, since the contract was for 2 years and because of the issues involved, the petitioner could not discharge the same. I could not discharge the same because they did not let me. The petitioner would have the liberty to file application for allowing the discharge of the function for full term. In case such application is made, the same would be considered by the respondent refinery in accordance with law, and by passing of a speaking order, both these writ petitions are accordingly allowed. Now, from day one, when this writ petition was filed, they had been telling the court, no, this is the writ petition doesn't lie. You have to go to the civil court for redressal of grievances. A writ court cannot entertain this writ petition. But in ABL, my lord, that is also a part of the judgment, my lord. At page 31, para 8, these are the case laws which the learned single judge has relied upon. At para 16, page 35. Now, a writ petition, I don't have to, if I want compensation, I don't have to go to the civil court again. I can file a writ petition for compensation. That, and if they're not agreeable to that, why didn't they go for a writ appeal? You don't appeal against the order you're dissatisfied with. You try to circumvent the court order, overreach the court order. There's a rule of law, my lord. Can a state instrumentality ignore the court of which they were party in the writ proceeding? They do not appeal the judgment and order. They had been doing one-sided, unilaterally, they had been taking decisions. Why did not they file a writ appeal before the learned division bench saying that no, we are not agreed by this order, you cannot pass this, the learned single judge is not competent to pass this order? Why didn't they go to the court? So they have taken the easiest way out. Forget about the courts. We have a judgment saying that if you don't participate in the tender, you are not allowed to challenge it. Issues are always different. In Tata Cellular also, the court has come to this. It's on a case-to-case basis. Now, when my contract is subsisting until 34/2000, let us assume that 34/2025. It is subsisting. The contract is there. Where is the letter of discharge that is called, you are discharged from this contract? Where is the letter? Let them produce the letter discharging my contract. That since you are not doing for the rest of the 6 months, we hereby rescind the contract. We have nothing to do with us anymore. Where is the letter? The letter of rescission of contract is not there. I remember in another Supreme Court matter, my lord, Honorable Justice Ms. Bella Trivedi, they have
pulled up the respondent number 1 for taking the court for a ride. Now that's what they're doing. They're taking this court for a ride. My humble submission is, if 6142, if this interim order is vacated, the subsequent writ petition 6142 goes for a toss. He's saying go to the civil court. Why should I go to the civil court? That means if I don't want to perform the contract, I'll file for damages. But I want to perform the contract for another 2 years because I've invested money. I've taken in man and materials to perform my contract. I've taken loans from the bank. Where will I go? I only seek, these are 12 days in between. Let this, my lord, my humble submission, let this I be disposed of. Let both the matters be heard on 8th of April. That's a Tuesday. It's a hearing day. My lord, 6142 has to be disposed. Now, if 6142, I'm not competent to speculate, but if 6142 is allowed, what will happen? If this interim order is vacated, what will happen? Other bidders will come to the court saying that we have done a bidding process, now they're not giving it to us. 10, 15 other bidders will come in with the same issue, they'll come in before the court. Just a personal vendetta of certain officers who are doing this. They want somebody else to do the contract. So the easy way out is to push me out. Easy way out for them is to push me out of the contract so that their own blue-eyed boys can come in, deprive me of my rights. And it is not that I'm asking for a right. This right has been given to me by the learned single judge of this honorable court. Where do I go? I'm only seeking a period of 12 days in between. Today is 26th, 8th of April, if my lordship takes both the matters, because we also want a disposal. We have other work to do. We have to pay off our employees. We are not big contractor. This contract is worth around 2 crore 80 lakhs. We are not big contractor. And we take loans from banks and employ people. Where will I go, my lord? So if this interim order is vacated, it will be a travesty of justice, man. And it will undermine the court order of a London single judge. It is the law of the land. Rightly or wrongly, they haven't gone to the division bench under the writ appeal. As on date, this judgment and order stands. To avoid this multiplicity of proceedings, more bidders will come in. 6142 will be infructuous. Mainly, my lord, that judgment and order allowing both the writ petitions will be rendered redundant. How can they circumvent the procedure of the court like this, my lord? This is blatant, my lord, miscarriage of justice. They're doing travesty of justice. They cannot do this when a court order is there. Had it been no court order, we have not participated in the tender, then yes, my writ petition would not have survived. It would have been thrown out. Since I'm not a bidder, you go. But when there's a previous case, there's a court order where the court has allowed me to perform the rest of my contract for another 2 years. How can they do this? And if your lordship says 6142, writ petition 6142,
yes.
Writ petition, kindly see the order sheet. They've been taking time and time. They don't want to finish up the writ petitions. Kindly see the order sheet, my lord. 3 weeks, 1 week, 2 weeks. They've been taking time and time because they had already planned it. That will subvert the course of justice and will float a new tender and tell the court that they have not participated in the tender, so they should be thrown out. The writ petition should be dismissed. Have some respect for the courts, my lord. This must submission.
The other writ petitions are pleadings are complete.
No, my lord, they have not.
My lord, kindly give me 1 minute's time. Please come to page 36. My learned friend's argument is based on the basis that there is a declaration in the earlier judgment of the court bench that he has a right to operate the contract for 2 years. If it is, then he is correct. If not, he is not correct. Please come to page 36. There are 2 paragraphs only, 17 and 18. In view of the aforesaid facts and circumstances, this court is of the opinion that a case for interference is made out. Accordingly, the termination order dated 6/11/23 is interfered with. Consequently, respondent is directed to allow the petitioner to complete the contractual liabilities in terms of the work order dated so and so. it is also made clear that respondent refinery cannot restrain the petitioner from engaging its own man for discharge of his duties. My lord, paragraph 17, reading of para 17, literally what follows is that, yes, termination was wrong. You have a right to complete the contractual period. And in doing so, you also have a right to engage your own man. You need not engage the contractual laborer, which are already there. Am I clear, my lord? Now please come to para 18. Since the contract was for 2 years, because of the issue involved, the petitioner could not discharge the same, comma. Petitioner would have liberty to file an application for allowing to discharge the functions for full term, and in case application is made, the same would be considered by the respondent refinery in accordance with law and by passing a speaking order. Now, if an application is filed by petitioner, he will be at liberty to apply for full term. Learned single judge did not make any declaration that he has a right to operate for full term. All that learned single judge said was he has liberty to apply for and will consider in accordance with law. Now, where is the declaration that he has a right to operate for full term, full 2-year term? Kindly see, my lord. Since the contract was for 2 years and because of the issues involved, the petitioner could not discharge the same. The petitioner would have the liberty to file an application for allowing to discharge the functions for the full term, and in case such an application is made, same would be considered by respondent refinery in accordance with law. Now, my lord, in accordance with law is very significant. Now, my lord, normally in a contractual term, once the period is over, it's not a fishery settlement where rule 8 is there. There is a period for extension. So I am to consider it. I have considered it. Now, assuming my consideration is wrong. Now in 6142 that will be decided. Now, my lord, my learned friend says even High Court can award damage. Now, how can High Court demand damage? To assess damage, my lord, there has to be factual determination. That can be done only by civil court. What High Court can give is a palliative. Supposing there is infringement of fundamental right under Article 21. Somebody is died in a police firing. Court can say, we are giving you a palliative. That is a different concept. Now, here Lordship is dealing with a contractual right. Here Specific Relief Act will come into play. What does Specific Relief Act say, my lord? When damage can be assessed, then there is no question of injunction, no question of performance. These are all fundamental principles, my lord. Now, had it been a case where in the judgment, a right would have been declared in his favor that no, whatever had happened, you have to be given full 2-year term now, then things would have been different. But all that single judge says was, he will have liberty to apply. And authority will consider in accordance. Authority has considered. Now that is under challenge. Therefore, I am saying, my lord, let us be very pragmatic about the whole issue. So therefore, my lord, end of the day, even if it is hard with that matter, as I have already submitted, this writ petition cannot be allowed, my lord. How can this writ petition be allowed? Where is the scope? The preponderance of judicial view is, my lord, in such matters, Lordship will relegate him to civil court to file damages. Even, my lord, in that the recent judgment of the Supreme Court, where even if, my lord, a wrong is committed in awarding a contract, Supreme Court says you file a civil suit for damage. We can't give, a court will not come to your rescue other. So therefore, my lord, the position is very clear. So it's wrong to say that his right to continue for 2 years has been declared by the court in the earlier round of litigation. All that court said was you can apply. He has applied, authority has considered. Lordship has seen the order. And it is also a correct fact, my lord. Initially, he has deserted the place. That's absolutely correct fact. When the other pleadings are brought in, then your lordship will know. After operating for some time, my lord, he stopped. And my lord, once you have gave your order, you should have come in. You should have entered possession, then you should have staked your claim. Then also things should have been different. You have defied that also. Instead, you have chosen to come to the court. In that view of the matter, my lord, this would be an abuse of the process of law. Therefore, lordships will vacate the interim order. That is my humble submission.
At para 18, my learned friend has already.
With the lordship's kind permission, can.
At para 18, but again, I'm coming to that. since my learned friend has pointed out, since the contract was for 2 years and because of the issues involved, the petitioner could not discharge the same. What are the issues that has been given in para 17? Issue is that they have restrained me from performing my contract. The petitioner would have the liberty to file application for allowing to discharge the functions of the full term, and in case such an application is made, the same would be considered by the respondent refinery in accordance with the law and by passing a speaking order. Now, why this para 18? Because tomorrow it is not incumbent on the court to speculate. I might not want to perform the contract and say, no, I want damages. I don't want to perform the contract anymore. So that liberty has been given. You file an application, let them dispose of this application. Okay. Now again in 38, page 38, that is the rejection of my 2-year thing, 2-year application, and NHAE page 37 is the letter, and 38. They have stated all the facts by rejecting it. Where is the law? Now they have in last third para, this is the only explanation for rejecting my claim for 2 years. Now, therefore, in view of the above, you are hereby directed to complete the contractual obligations, and the contract for remaining period of contract is up to 34/2025, subject to the outcome of the writ appeal filed by Dilip Sharma and others in the Honorable High Court. Well, where have they stated the principles of natural justice, or for what reasons you have been rejected the full 2-year term? Where is the speaking? This is not a speaking order. That is why we have counted to 6142. Does it speak of any law, any principles of natural justice, any balance of convenience? Nothing. They should have quoted for these and these reasons we reject it. They have not assigned any reasons why they have rejected this application. And my lord, may dispose of this IA, and 8th of April, my lord may hold both the matters permanently.
Okay, I'm disposing of this IA. I'll pass orders. What about in the writ petition 738, pleadings are complete?
No, no.
Dusty service on what? You took dusty service on? You are appearing, isn't it?
Yes, Lordship.
You are filing your affidavit or not?
No, Lordship.
No, are you filing?
Yeah. Yes, I will file it in 1 week.
1 week, okay.
Almost ready, Lordship. Actually, affidavit is almost ready. I have sent it.
Okay. Heard Mr. R. Sharma, Senior Counsel, assisted by MS
P. Fukan.
P. Fukan for the petition. That is in WBC 738, huh? MS R. Kataki. Kakuti. R. Kakuti, learned counsel. Appearing for all the respondents. Submits that she'll be filing counter affidavit within a period of 1 week from today. Stop. Praise allowed. You would like to file a rejoinder?
My lord.
Let such affidavit be filed on or before 3rd of April 2025. Thereafter, petitioner is also permitted to file reply to the affidavit if so advised. List on. Heard. Can you have it on 8? Possible? List the matter on 8 April. Okay. And in 6142. Here also affidavit has come? Not yet.
Not yet.
Can you file your affidavit
Yes.
within this period? Heard Mr. R. Sharma, the Senior Counsel, assisted by MS R. What is it? Kakuti. Learned Counsel for the respondents is praised for 1 week time. This also same order you pass on or before so and so on 8. In the IA, I'll pass orders.
Obliged. My lord, if a small, because we are also very troubled with this. My lord, this board is petition may come up for final disposal on 8th, my lord, if
That's
possible.
what I'm saying. This
Right.
matter not for final.
Obliged.
Twenty-two of daily list, admission.
In this case, I am appealing for the respondent number 2 and 3. We have filed a affidavit in opposition. Basically, my lord, the payment of contractual bill. But in the affidavit, we have disputed the execution, completion of the executed work as well as.
So the amount is disputed.
Amount is disputed, even execution is also disputed.
Okay. You are appealing for which respondent?
2 and 3.
None appears for the petition. Who appears for the state? Science and Technology. Mr. M. Chitial and the Governor appears for the respondent number 1. And Mr. PG Cycle and the Senior Counsel, assisted by Mr.
P. Boardwell.
P. Bordelais appears for the respondents 2 and 3.
2 and 3.
When shall we list? After 2 weeks? Would you petitioners counsel is not list after?
23.
May it please your lord. As the senior counsel is on like said part hard matter, madam. This is court number 6. Kindly matter may be adjourned for the day, madam.
Who's your senior?
Shishi Datta, sir.
Okay, on request made on behalf of S. Datta, the senior counsel for the petition. List after?
Bihu vacation, madam.
I'm showing for respondent number 1, madam.
MS?
N Burman.
M. Burman.
N Burman.
N. Burman. Leonard Standing Counsel.
Appear on behalf of Dean at my lord. On behalf of Dean at my lord.
Appearing on behalf of Dean Leonard, Senior Governor Advocate for the respondent number 1.
Obliged.
24.
Please your lordship. My lord, where the petitioner, my lord, initially he had established a brick industry, my lord, in 2008, my lord, or over his parental land, and also he took 5 acres of land on lease, my lord. And then he started his construction and everything almost done, my lord. In the meantime, my lord, the respondent authorities, they have, my lord, established, they have, my lord, started it for 400.
Who appears for the respondent?
Respondent.
Assam Power Grid.
Power Grid, my lord.
Notice has been served?
Yes, my lord. On all the occasions they appeared, my lord. Because of this electric line, my lord, over the land of where the brick industry was established, my lord, the petitioner submitted, notice was issued. Your lordship may kindly see the notice served by the Power Grid, my lord. Notice is and after receiving notice, the petitioner submitted his objection. He submitted representation before the deputy commissioner, my lord, for my lord payment of adequate compensation, my lord. So subsequently, my lord, list prepared, my lord, for payment of compensation, but his name was not included. So the petitioner filed a writ petition before this honorable court, and the matter was disposed of with a direction, annexure M, my lord, page 38, my lord. Direction, my lord, there is a direction to hold an inquiry, and accordingly, page 40 is the relevant portion, my lord. Mm.
2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 . 2 .
And my lord, order was supposed to be passed, my lord. But your lordship may kindly see, I have annexed two numbers of my lord enquiry reports. My lord, the enquiry was conducted by the circle officer. Verification, my lord. Annexure J at page 28, my lord. Page 20.
Anyway, anybody for the power grid? I think that is the main respondent. Last occasion also, they were not present.
Very MZ Ahmed. Your
Okay,
lordship.
then we'll fix a date.
Yes, my lord, since they are not here.
Heard SP Chowdhury and the counsel for the petition. Also heard Mr. You are appearing? M. Chitia, land revenue.
Revenue.
Oh. Also heard Mr. J. Henry.
24.
Then standing counsel, land revenue. For the response number 1. And Mr. M. Chitia, land governance. For the responders, 2, 3. 2, 3 and 5, correct?
Yes, my lord.
Lordship, I am for one, Lordship.
Yeah, 2, 3, 5.
2, 3, 5, my lord.
None appears on behalf of the respondent number 4, oblique. Power Grid Corporation of Assam Power Grid, Assam Power Grid Corporation. Please, the matter after 1 week,
MZ Ahmed. My lord, the date may be fixed, my lord.
the matter again on. Okay, then after Bihu on 23rd.
Lordship, may reflect the SC revenue in the list, Lordship, it is not clear.
Registry is also directed to reflect the name of the Leonard Standing Council, SC revenue in the
Revenue,
first
DMD.
25.
Okay.
May please, your lordship. Lordship, the matter pertains to non-payment of admitted contractual dues. Affidavit is filed. It was filed way back in 2019. And they have admitted, only thing is they have placed for fund, your lordship. The fund they did not receive.
Who's supposed to pay?
My lord, as per affidavit, my lord, letter was sent to my lord, Commissioner and Secretary Revenue and Disaster Management, my lord.
Respondent 1, your lordship. They did not file anything, and the deputy commissioner has paid for fund from the respondent number 1.
Enukshire. Yeah, Hendik.
Lordship, some time may be given, but I have to take instruction.
2019.
2019 matter.
Yes, proposal was also sent in 2018, my lord. He have to take instruction, my lord.
Might have already been released or not, that instruction I have.
No, he has not got to.
So let me take instruction, my lord, 10% to that next I have, Lordship, 9/4/2018.
Heard, Mr.
BJ Mukherjee. BJ Mukherjee.
VG Mukherjee, Leonard Council for the petition. On request made by J. Hendik, Leonard Standing Council, Revenue. And disaster management. How much time you require?
Only 2 weeks. After due,
2 weeks time is allowed to enable him to file, to enable him to receive instructions. List after 2 weeks.
27.
May please, your lordship. Lordship, matter regarding compensation, but here lordship matter, this type of matter has been dealing by civil bench 5, your lordship. Civil bench 5 matter actually, this matter.
Yes, civil bench 5 matter.
If your lordship will pursue, then I will continue. Otherwise, lordship may take the rest to please the before of grievance.
Let's check up with the civil. I'm praying for compensation. Okay, let. Yes, civil division, right? So with petition. Huh? Okay, learned counsel for the petitioner submits that this matter pertains to civil bench 5. Para registry to verify and list according.
28,
May I please, dear Lordship? Lordship, in this case, we are supposed to file an IA for impleadment, Lordship. Today morning, I have filed. Let the matter come up after 2 weeks, Lordship.
On request made by MS.
ADAS.
Learning counsel for list up to 2 weeks.
29,
May I please, Lordship? My lord, it is a non-payment of contractor's bill, my lord. It is the admitted amount, my lord, and respondent also filed their affidavit in opposition, whereby it is admitted that the work is completely done.
Revenue.
They have a newly implemented whether revenue party.
Hmm?
We have made a party, newly implemented.
Huh.
But if we have not taken any of that, instruct also. Some time will be given.
No, my lord, on that very day, my lord.
Order was. No, that party was made on in the 2024. Last part of this October. Only October they made.
Revenue was implemented the party on 24/1/2025. You want type?
All the copies are, my lord, on that very day.
Only one copy was some, we have to take my lord that send it to them on the department.
It is not the duty of the petitioner that double copy is to be served.
Definitely they have to serve also. Only one
Okay.
copy, how can my lord?
Okay. Heard Mr. K.U. Ahmad, learned counsel for the petitioner. On request made by Mr. J. Handip, learned standing counsel revenue department. How much time you require? 2 weeks time is allowed.
My lord, let me finish my
To enable him to receive instructions. Please, no,
Last part of the.
28 April.
Obliged.
30,
Lordship, I pay for some time. We have communicated, Lordship, with the Deputy Commissioner. Some time may be given.
Okay, heard yes, sir. On request made by K. Google, learned additional. How much time?
After reopening, Lordship.
2 weeks time is allowed to file, to enable him to receive instructions. Please, after 2 weeks.
31,
Also, my non-payment of contractual bill, my. What has been completed, handed over.
Receive the instructions. And they seem to be proper. Let me place like council be go. He's on his way. But he'll be better be able to appraise the court. On his way.
You've received instructions.
No, sir, we've
Is
received.
it an admitted amount?
An amount as it seems is admitted. That's right.
Let us see.
I
your
black
ins-
mark it, my lord. My two flag marks, one is the proposal, other is the my lord completion certificate.
Only thing, Lordship, my lord, regarding release of the amount, Lordship will give us some time. Because it will have to be in the new financial year. And in the first one, in 2022 itself, the proposal was submitted. But Lordship will give a direction. Just come from the executive engineer. File करेंगे. Whatever amount is there, Lordship will direct that they should verify and it should be paid in the time limit.
Heard Mr. Biji Ghosh, learned counsel for the. Stop. Where's your work order?
Lordship, no, my lord, the work order, Lordship will find that pays, my lord. It is a tender at page 18, my lord.
Okay, pursuant to a press notice.
Yes, my lord.
Dated 20 October 2014. The petitioner submitted his bid for the work within inverted comma upgradation of SC/ST/PHC on Community Health Center within bracket phase-1.
Yes.
In Barak Valley under the CM's special package under annual plan 2013-2014. Close inverted comma. Then
My lord will find that our bid was accepted. Then Lordship will find from my lord issue of the notice to proceed at page 24.
the bid of the petitioner was accepted. And the chief engineer PWD within bracket building Assam issued within inverted comma issue of notice to proceed with the work on 7th of March 2015 to the petitioner with regard to the said package. Stop. The petitioner accordingly completed the work.
Then my lord. And the completion certificate, Lordship will find at page 85.
1 minute. The petitioner completed the entire work on 30/9/2021 and handing and taking over also took place on 4/1/2021
22, my lord.
or 2022. Stop. Thereafter, the petitioner submitted its final bill on 15/3/2022.
Yes.
For an amount of rupees
3 crores 29 lakhs.
3,29,82,740.
Yes, ma'am.
Where is that?
Well, 85.
85, page 85, that is the admitted amount, my lord. Lordship may kindly, page 85, that is the final bill amount of present bill value. 3.3 crores 29 lakh 82,720.
No, when did you submit that, your bill?
Bill, my lord? 3 crore 29.
Don't.
Yes, my lord.
Cancel that one. The completion certificate.
Yes.
Was also issued.
Yes.
By the executive engineer PWT. Karimganj District Territorial, what is this?
It is my lord, Karimganj Territorial.
District Territorial
district territorial
Building Division,
building division. Karimganj.
which was countersigned by the Assistant Executive Engineer, PWT.
My lordship will also, my lordship, page 124.
124.
1 minute, PWT. Stop. Thereafter, comma, the petitioner submitted its final bill on 15/3/2022 on 15 for rupees 3, 29, 82, 74.
Page 124, lordship will see. My lord, after deducting from 3 crores 29,000 or 29 lakhs 82,720 an amount of rupees 2 crores 62,000 784. The remaining will be my lord 1 crore 29,19963 at page 124. Lordship will see the deduction. Total value of work done, supplies made to date is 3 crores 29 lakhs.
My lord, that is the cumulative value, my lord. Full value is still.
So, my lord, they will verify. Can't say exactly.
Stop.
Whatever is due should be
Yes,
verified.
yes, my lord. That should not be, yes, it's problem.
The Executive Engineer, PWT, Silchar, Sonai and Dhulia Territorial Building Division also sent a proposal for revalidation of administrative approval for the said work to the Chief Engineer, PWD Building, Health and Education, Assam on 12/9/2022. Correct?
Yes, please.
Stop. However, as the said amount, as the said outstanding due has not been paid to the petitioner. The petitioner is before this court by way of the following information. For Mr. B. Gogoi, Learned, Standing Counsel, PWD.
PWD and health. Lordship
And Health Department, on instructions, submits that the outstanding due is an admitted amount. However, he submits that the authorities may be allowed to re-verify and thereafter pay the said admitted amount within a specific period of time. After hearing the learned counsel for the parties, this said petition is disposed of. Directing the authorities in the.
My lord, here it will be, lordship will say all respondents because
Directing
amount will have been provided by the health.
Directing the respondents
Work executed by PWD.
to have a re-verification
My lord.
with regard to the outstanding dues claimed by the petition. And thereafter pay the admitted amount to the petitioner within a period of.
He will say, my lord, 6 months, my lord.
My lord, 6 months, too much, my lord, because we are.
4 months, will
4 months
but you will get that.
from the date of.
Only thing, my lord,
of
she
a
will
copy
indicate,
of
my
the
lord,
order of
got the instruction from respondent number 7. Is the.
All the respondent, my lord.
On instructions, from the respondent number 7. Right.
Obliged.
This, I'm keeping this.
Lordship.
32,
32, lordship, I have received instruction from the lordship superintendent of police, lordship. He says that it was sent to the deputy commissioner. From the deputy commissioner, instruction is required. So we have posted after 10 days, lordship. Otherwise, the bill is forwarded to the district commissioner. lordship.
Okay, heard Mr. N. Uddin, and the counsel for the petitioner, Mr. K. Gowai,
Yes, sir, no?
additional senior government, okay. Praise for 2 weeks time to
Lordship,
enable
lordship,
them
yes.
to receive instructions. Praise
Date
the
will be fixed. my lord.
list on 28 April.
Obliged.
33, 34 and 35.
Wait, please, your lordship. This matter, I just so lordship, I'll give a list of the decisions I'm relying on. This will.
Just
Want the
a
flavor?
request for video.
I've just given a list of the dishes now, point wise. Let's. This citation was not there. This citation was not there.
It's extra beyond this.
Yes,
Okay,
it's included in the bunch.
okay,
It's included in the note.
okay.
Just for Lordship's convenience, I've taken out the printout. I've not added anything new.
Oh, this, okay, okay. I've heard this already.
Yes, Lordship, the matter may be closed and judgment reserved.
Yeah, otherwise it's not shown parted, that's why I was a little confused.
No. Just for this actually, Lordship. I've
Okay,
kept.
okay, okay. You wanted to submit this.
I just wanted to give this.
Heard MS.M. Hazarika, and a senior counsel assisted by MS.S. Newark.
Yes, sir.
For the petitioner, learned counsel for the petitioner. Also heard Mr. D. Saike. Saike will have.
He is there.
Learned senior counsel assisted by Mr. M. K. Das. Learned counsel for the respondents 1 to 4 and Mr. A. Hanukar.
For R5.
Learned counsel for the respondent number 5. Was Ganguly wanted to join by video.
That was closed, Lordship. He had.
And Mr. A. Ganguly, learned counsel for the petitioner in WBC 5382 of 2024. Stop. Hearing concluded, judgment results. This is the matter that you were expressing urgency in the matter.
Yes, sir.
They were expecting.
Not, oh, okay, not you, okay.
Okay. Obliged.
36.
Yes.
Here, other side has filed an additional affidavit. We will file the affidavit in reply against that.
Additional affidavit?
They filed the additional affidavit
When did you file it?
earlier on this. We will file the reply affidavit.
No, when was it filed?
It was long back, your lordship, and one date adjournment has already been taken by them for reply.
Okay, that was filed on 25th of February.
Lordship,
Yes.
we
1 minute.
And secondly, your lordship, this is the just judgment and nothing special.
Lordship, we, this council, Mr. Anand has gone to Bihar to attend his death rituals of his grandmother. So we pay for some time to file it.
These are just a judgment of district court and the demolition certificate issued by them.
Last time also you were given time to file your reply.
Today we intend to file, but Guest Council, Mr. Anand, we leave notice there Lordship in the cause list. We have already filed a letter of absence. So he is going to be here to attend his death rituals of his own deceased grandmother. Also, we pay for some time, Lordship.
Your lordship, my submission is there. They have applied, they have applied for regulation of the unauthorized construction.
I'm not granting you further time.
That is,
Next date we'll try to dispose of this.
that was
Next
6
day.
years back, your lordship. And no action was taken by the GMC. And before coming to this court, I wrote the complaint to the CMO office. And your lordship, just a minute, in my additional affidavit, please go through 33A. Here, they saw a notice asking for documents was CPL CMO. Chief Minister wrote to the office, wrote to the GMC, and they simply issued a notice, and then the respondent number filed an application. No, only one reply, and the GMC slept over the issue.
We pay for some time, Lordship.
Okay, heard Mr. Sanjay Sharma,
Sanjay Sharma.
petitioner in person.
Essay Bhakti.
S.A. Bhakti,
Anand.
counsel for the respond number 3.
Yes, we have-
Praise for how much time?
Your lordship, just
After Bihu, Lordship. Any day.
before 7, sir, it is all, it is the GMC to act. They have nothing to say.
And if it is going also, we will after Bihu, Lordship.
Okay, praise for 2 weeks time to file
Your
response,
lordship give me a specific date that will be
to file
better.
reply to the additional affidavit filed by the petitioner. The prayers allowed. List on
Sir, lordship, after 22 and 23rd April, lordship, after that. It will be out of session, lordship.
Okay, we'll have it on 25th.
Lordship,
April.
lordship.
37.
Lordship, here, in this matter, we have already filed our reply affidavit against the additional affidavit. Last week only, we have already filed. But and also we have.
Hearing is very clear, my lord. He was. Argument proven as required.
Lordship, Lordship, we have already filed a reply affidavit last week. But the affidavit has not been tagged along with the record, Lordship.
When was it filed?
Friday, Lordship.
Give the date only, give the date. There's no point like
21/3/25.
21/3. Mr. S.A. Bhaktir.
S.A. Bhaktiyar.
Bhaktiyar, learned counsel for the petitioner submits that he has filed an affidavit in reply to the counter affidavit filed by the Forest Department on 21/3/2025. Stop. Registry to verify and place the same one.
Let it be come along with the record.
If in order. Stop. List after
8th of April, Lordship, Tuesday, it will be hearing, Lordship.
8th of April, I fixed many cases. 10th April.
10th, much obliged.
39.
Wait, my lord, similar matter has been heard and reserved for judgment in another court. Honorable Justice S. Soikia, Your Honor. So matter.
My lord, next is my lord. In WC 2068/21, my lord. Similar matters have been heard and judgment has been reserved, my lord. This matter pertains to granting of eligibility certificate to the petitioner, my lord.
So what do you want? You want that outcome?
My lord. If my lord pleases.
Learned counsel for the party submits that in a similar matter, a judgment has been reserved and accordingly prays that the matter be listed after 6 weeks.
It's fine. After reading, my lord, I appear for respondent number 2 and 3. I'm appearing for the first time. My lord, we would like to file our affidavit in the instant matter.
Okay, then you cancel that order. Heard, Mr.
P. Sharma.
Learned counsel for petitioner. Mr.
P.R. Sharma on
P.R. Sharma.
Nishan Das. On behalf of Mr. Nitanda.
Mr. Learned counsel appearing on behalf of Mr.
Nishan Das.
Nishan Das, learned counsel for the respondents to entry. Praise for how much time?
My lord, 2 weeks time.
Praise for 2 weeks time to file counter affidavit. Praise allowed, list of the 2 weeks.
What's the time for the respondent 1 and 5?
Mr.
H. Bora for respondent number 4, my lord.
H. Boral, learned counsel appears for respondent number 4.
I'm for 1 and 5, lordship, for industries and commerce.
And Mr.
N. Kalita on behalf of A. Kalita.
Learned standing counsel, industries and commerce appears for respondents 1 and 5.
Obliged. 40. Lordship, we have received a written instruction, lordship, to like to file affidavit.
You want to file affidavit? Heard, Mr.
Jay Sharma.
Learned counsel for the Mr.
R. Gogoi.
R. Gogoi, learned standing counsel,
Yes,
Forest
Forest
Department.
Department.
Submits that he has received instructions and prays for how much time?
2 weeks time.
2 weeks time to file contract.
May paper date after, immediately after vacation.
Yes, after. Let it come up after 2 weeks, we'll see. After
Obliged.
2 weeks.
Obliged.
41.
May it please your lordship. My lord, non-payment of contractual dues of an admitted amount. Lordship will kindly see the work order at page 80.
The affidavit has come.
Affidavit hasn't come, even on the last occasion they prayed.
What is wrong?
Lordship may dispose of the matter, directing the shipping engineer to verify and pay.
Who's supposed to pay the bill?
The water resources department.
Water resources, who's the authority?
The direction perhaps can be given to the commissioner and secretary. No. My lord, the chief engineer.
Respondent three,
Respondent number 3.
where's your work order?
Your lordship will find it at page number 18. The
Hmm.
utilization certificate at page 20 and their admitted liability.
Where's the NIT?
My lord, the NIT has not been annexed, my lord. The work order has been annexed at page.
Okay,
18.
hurt Mr. D. Chakravarti and counsel for the petitioner. Stop. Also hurt Mr. C. Sharma and standing counsel, water resources. No, 1 minute, there are other respondents also.
My lord, finance is here.
Water resources department for the respondents, 1, 3, 4, 5,
6 and 7.
6 and 7. Finance, Mr. A. Chalial and standing counsel finance appears for the respondent. Para. This annexure 18.
Annexure 18 is the work order, my lord.
The petitioner was issued a work order on 18/5/2019 by the executive engineer, Silcha Water Resources Division for, within inverted commas, repair and renovation of all Battery sluice and all Burkhai sluice, close inverted comma, under the scheme of construction of sluice for additional opening over Battery River, including dredging, close bracket, regrading and resectioning, close bracket, of Burkhai Nala. Page 18 you'll get. Stop. When did you complete?
My lord, your lordship will kindly come to page number 20. It's a utilization certificate where they have said that the 100% work was completed in the year 2022.
The petitioner completed the said work. And accordingly, as utilization certificate was issued by the executive engineer.
Yes, ma'am.
Kachar, WR division. Countersigned by account officer, Kachar, WR division, Silchar. Stop. For an amount of rupees,
3,15,039.
where can I get that?
Page number 25.
Okay, no, then don't say that. Stop.
My representation is at page 23, man.
However, comma, the respondents did not clear the final bill of the petitioner amounting to rupees 3,15039, correct?
Yes, ma'am.
And accordingly, the petitioner made a representation before the executive engineer, Kacha Water Resources Division, Silchar, on 19/11/2024 for issuance of a liability certificate for the work done by the staff. Consequent thereto, comma, the executive engineer, comma, Kacha WR Division, Silchar, issued a liability certificate on 4/12/2024 showing a liability of rupees 3,15039 for the work done by the petitioner. Stop. However, despite issuance of the liability certificate, the outstanding due payable to the petitioner has not been paid, and accordingly, the petitioner is before this court by way of the present petition. Stop. Para. Mr. C. Sharma, Learned Standing Council Water Resources Department submits that the respondents may be allowed to have a re-verification and thereafter pay the admitted due to the petitioner within a specific period of time. Stop. Para. Considering the submission made by the Learned Standing Council Water Resources Department, this writ petition is disposed of. Directing the Chief Engineer, Water Resources Department, oblique respondent number 3, respondent number 3, to have a re-verification of the claim made by the petition. And thereafter, if the claim made by the petitioner is found to be admitted, the same should be paid to the petitioner within a period of
6 weeks. Lord.
6 weeks.
Well,
6
the
weeks.
entire exercise can be carried out within a time frame, my lord.
Yeah.
This verification and payment
That
can
will
be done.
within the period of 3 months from the date of receipt of a copy of the order with the appropriate observations and directions to petition.
Deeply up.
42,
Lordship, little accommodation, we have sent wrong file. Instead of 125, they have sent 1025. Any day, Lordship. Today, they have sent wrong file. Lordship. After we should put confirmation.
You heard, Mr.
After
Lead
due,
us, Your Honor.
Learned Counsel for the petition.
Only request is the date may be fixed.
after due, any day.
On
Lordship,
request made by
response from
Mr. K. Gogoi, Learned Addition, Senior Commander. List the matter on.
my brother did sell it, I said,
When do you want?
after due, any date as per my brother's convenience.
25th April.
22nd, Your Honor, may consider.
That's a hearing day.
Very well, Your Honor. Next
20
week
we'll have
after
it.
that,
We'll have
28th.
Okay.
Deeply obliged.
43,
Well, the matter before proceeding start, when the BCC is a necessary party. It have to be implemented, Melo, because the forest royalty certificates were issued by DFO Baksa, who is a
Page 31.
comes under BTC matters.
Page
30.
Mushalpur.
Page 31. It official communication, my lord.
Then you implead the party.
Yes, yes, I will.
Mr.
And Burman.
And
Burman.
Learned Counsel for the petitioner prays for how much time? 1 week? 1 week time to file an appropriate application for impleadment of necessary parties. Praise allowed. Please, chapter 1.
23 of supplementary list, admission.
Lectures on this.
73,
None appears for the petition. Please, chapter 1.
44 of daily list, orders.
May it please your lordship. Lordship, in this case, I'm led by Mr. S. Datta, my senior. He is in legs in court number 17. So. Although lordship, there is an IA that we have filed in this contempt petition, it has come up for the first time. So your lordship can issue the notice.
Now, what is this IA?
Issue, there was a direction from this court to pass a speaking order. We passed the speaking order. Now they are finding fault in the speaking order. And perhaps I just had a look at the record, my lord. The IA, they want to initiate perjury proceeding against us. Just because the speaking order didn't satisfy them. But and we are also in receipt of the IA, my lord. So we may be furnished a copy.
If they're appearing, we will furnish the copy because it's an, we thought that notice will go, Lordship.
My lord, notice.
Miss
IDAS,
India, IDAS
IDAS.
for the applicant. Issue notice. Applicant to take steps for service of notice on the respondents 1 and 2 by registered post AD within 1 week. List after 4 weeks.
Deeply obliged.
45.
Please, Your Lordship, we received the instructions, Your Lord. It has asked regarding the contempt proceeding, which is found to be illegal, Your Lordship.
Item 45, 46, and
45.
47. These 3 meters, they have passed the speaking order. Then they will proceed.
Same order by the same order or different orders?
Different orders.
Okay, let us do one thing. This is item
45.
Nurul Haq. Then we'll cost the contempt. You can challenge this.
Yes, madam.
46 and 47.
Okay,
I am paying 47.
okay, you are appealing 45.
45 and 46, Your Lord.
1 minute. MS
I am Barua for Mr. P. Nayak, Your Lord.
Adam Barwa, Learned Counsel, appearing on behalf of Mr. P. Naik, Learned
Council
Counsel.
BTC.
Not the BTC, this is contempt.
Contempt.
Oh, contempt, sir. Correspondent.
For the sole respondent
Correspondent.
has furnished an order dated 5th February 2025. Issued by the Secretary, Borderland Territorial Council, whereby the claim of the petitioner for payment against the works allotted from the scheme under SCA to TSP and other grants has been found not sustainable and accordingly rejected. Stop. On the ground that how is this? The work orders were issued illegally, fraudulently, with the malafide intention to cause huge loss to public exchequer. Stop. But on considering of the order dated 5th March, February 2024, this court is of the considered opinion that the respondents have substantially complied with the directions passed by this court. Accordingly, this contempt petition is closed. The order dated 5th February 2025 is placed on the court. On top, you just heard Mr.
A. Boro.
A. Boro, President Counsel. Huh? Okay. And 46?
Same, madam.
Same.
Just say produce an order dated 24th September 2024. Issued by the Secretary Borderland Territorial Council. Then the contents are the same. Contempt clause. Here it will be MS RB Bora. Learned Counsel. There is a sole respondent.
No, Lordship.
Two respondents.
That second case.
Second case. Mr. Akasdeep is there, yes, sir.
Akasdeep, I am appearing for respondent number 2. Today we have filed a petition.
Item 46.
47.
No, 46.
No,
Oh, 46 to do that.
46. Appearing for the respondents. And in item 47, heard so and so, MS RB Bora, Learned Counsel, appearing on behalf of the respondents,
Respondency.
has produced an order dated 3rd September 2024, issued by the Secretary, Berlin Territorial Council. Contents are same. Close.
48 yet to receive the order.
It will come after 2 weeks.
38 Borough Land Council for the petition. Item 48. On request made by RB Borough Land Council for the respondents.
Yet to file a colored number lordship. Have not filed a colored number lordship. Lordship.
List the matter after 2 weeks to enable her to receive instructions.
Obliged.
54,
Please, your lordship. Okay, I'm appearing for the sole respondent. On last occasion, I have submitted the order. My lord has made it part of record. They seek time to take instructions whether the same was done or not on last occasion. My lord will be pleased to peruse the last order passed by your lord.
Where is the council? Okay, we'll give you one chance.
My lord.
None appears for the petitioner. MS
SG Borua.
SG Barua, Leonard Council, appears on behalf of the sole
Sole
respondent.
respondent.
List after 1 week.
My lord. Published.
56,
Lordship, in item number 55, I am the counsel for the lordship petitioner, but without informing us, lordship, matter has been mentioned by the standing counsel of the department, lordship. Therefore, lordship, matter may be fixed on a fixed date, lordship, because there was a direction from this honorable court, lordship, to release the subsistence allowance within a period of 1 month. And this direction was passed on 16/10/2023. That has not been complied with, Lord.
Who took the order? Mona Lisa, I've signed it already, I think. She must have-
55.
Morning it was mentioned.
55 without informing us, Lordship mentioned, because we are waiting here. And senior counsel, Lordship, Pijasrika is also waiting for that case. Lord.
No. This was mentioned by the Elementary Education Standing Council in the IA.
Yes, your lordship, yes. Probably S Kumar.
But
S.
without,
Kumar mentioned.
without informing us, Lordship.
S.
Because
Kumar.
I am for the respondent in that IA, Lordship.
Okay.
Therefore, Lordship,
Oh,
date may be
how
fixed.
much time was given? 2 weeks. Instead of 2 weeks. We'll have it on 21st April.
Yes, sir.
I'll inform.
Yes, inform.
I'll.
Highly obliged.
56,
This is lordship, we need some time to file affidavit, lordship. We have
What
received
is coming in the orders?
lordship.
Any private party?
Private parties. Not there, probably, lordship. Private party is there, it's number 7, where the notice is. Also the notice is also.
Maybe listen, lordship, as per Lozama Court Order 2011/2024, service has been already completed.
Okay. Heard, Mr.
A Khalek.
Khalid Learning Council for the petition. Peruse the proceedings of the Lawazima Court dated 2011-2024. The notice on the respondents 3, 4, and 7 shall be deemed to be complete. Stop. On request made by Mr. K. Gogoi, Leonard, additional senior government. How much time?
4 weeks notice. In the
4
meantime,
weeks
we'll
time
file
is
it.
allowed to file counter affidavits. List after 4 weeks in the admission column.
Obliged. 57, 58.
May I please receive? Malad, as per office note dated Malad 24/3/2025, service is awaited. Upon number 4 and 5 lots.
In the writ petition,
In the writ petition lots. Neither AD card nor unsub notice received back lots.
it was sent on 7/3, isn't it?
Yes, lots. It's only. Await service report.
Await service report on the respondents 4 and 5. Yes. And list the matter after 2 weeks.
Interim order may be continued.
Huh?
Interim order is there.
Interim order possible to continue till the next return. And what about in the contempt?
Contempt may be closed lawsuit. They have complied.
Huh?
Already they have open lawsuit. They party.
In the contempt heard Mr.
D. Gogoi.
D. Gogoi, Learned Counsel for the petition. The notice also not gone.
Yes, yes, because they have not complied with, therefore.
So you withdraw it instead
Yes,
of,
sir.
huh?
Yes.
Mr. D. Gogoi, Learned Counsel for the price for withdrawal of this contempt. Contempt petition is accordingly closed on withdrawal.
Highly obliged.
59.
Well, agree. Yes.
8, please, my lord. I appear for respondent number 3, my senior, Mr. Sanjay Mitra. My lord, we have just entered appearance. We have filed our Vakalatnama today. My lord, pursuant to the last order passed by this honorable court, we would like to file a IA, my lord, challenging the Dietary.
That is up to you. That is up to you. You don't need the permission from this court.
Yes,
You're entering appearance on behalf of?
Mr. Sanjay Mitra, we have filed our Vakalatnama. My lord, if I may kindly. Today we have filed Vakalatnama.
You're entering appearance on behalf of?
Mr. Sanjay, respondent number 3, my. Sorry.
3. Who appears for 1 and 2?
May please, Your Lordship.
10/3/2025. Okay.
Lordship, we have made a party in this matter, Lordship, but we haven't received any copy as on that, Lordship.
No, no, which?
Respondent number 4, Lordship. And our name also not shown in the cause.
Lordship, as per the office note 24/3/2025, it says we have already taken steps, but it's not completed.
That was sent on 10/3.
Yes, my lord.
We'll have to await.
Yes,
Respondent number 4, you are for what?
Industrial, yes, Lord.
Huh?
We have not received any copy, Lordship. I mean, petition copy, Lord.
You've served extra copies?
Lordship, we will serve it.
You've
I
served-
believe, don't have to be acknowledgement. I'll serve the copy. Lord.
Yes, sir.
And Lordship, our name may be, shown.
Okay, heard Miss Valentina and counsel for the petition. Stop. Mr. Pierre Sharma, learned counsel, appearing on behalf of Mr.
Sanjay Mitra.
S. Mitra, learned counsel, enters appearance for the respondent number
3.
3. Stop. Para. Await service report on the respondent number 1 and 2.
Lordship,
And-
1, 2, and 3.
3 is appearing.
Oh, it's
1 and 2 and list the matter after 2 weeks.
Lordship, there is an interim order working in my favor.
Okay, 1 minute. Interim order passed earlier to continue till the next voting date. Stop. Registry is also directed to reflect the name of the learned standing council, industries and commerce in the cost list.
60.
Maybe lordship. My lord, on 19/3/2025, your lordship directed us to take steps upon the official respondents. In additionally, Justice service of respondent number 6 and 7. So we have taken steps, and the respondent number 6 and 7 has also received the notice, but it is coming. I have been sent copies by WhatsApp. So I think that is not proper.
You'll have to file a
Yes, the
affidavit.
affidavit on justice service. And in spite of Lordship's order, my lord, they have not provided me the tender papers. So that may be asked to be provided to me. And this is my letter. I again and again, and let's see this. They have received the letter, and I also requested in writing that give me the tender paper. They have not given. So
Tender paper, you'll get it from the website, I think.
So
Is
this-
it not? I don't know.
The main website, again, today, nowadays, otherwise by the board works, not from the our part.
It's already receipt has come, but it is on WhatsApp, so that's why.
Okay. Tender paper will be in the website. You can
Then
download
the
it.
lordship may kindly observe that. I will definitely will collect.
Why should I observe that? Only thing is that what I'm going to say is that you want to file a dusty service affidavit.
Justice has already served
Oh.
on them. I will file affidavit.
Within 1 week, I'll give you.
And
Mr. M.U. Mahmood, learned counsel for the petitioner submits that the notice on the respondent number 6 and 7 has been completed by Dusty Service and prays for a week's time to file an affidavit to that effect. Stop. The prayer is allowed. List after 1 week.
Interim order passed earlier.
Interim order passed early to continue till the next suit.
Published.
Finish.